Hello, how's everyone doing? I hope everyone's having a wonderful day. Hopefully everyone can hear me. Hopefully everything is good. Yeah, it's an interesting day today. So let me just see here. All right. We got a whole bunch of things to talk about today. I hope everyone is down with a bonus stream. We are, this is not my sort of usual scheduled time, but we are doing a stream anyway because holy crap, there's a whole bunch of stuff. Oh, where's the boom? I am sorry. I'm sorry. We'll let's see. Boom. We'll have to do that over again. All right. So there's been a whole lot of developments in the Karen Reid file, a ton of motions and movements and things stirring, and yeah, let's talk about some of them. I don't know if we can talk about all of them, but we can talk about some of them because yeah, there's a lot going on. So where do we start? Where do we begin? It's because it's like, oh, let me sum up. No, there is too much. Let me. It's like, where do you even start with this? Because there's just so much stuff that's been going on, and it's just so crazy. And some of it is absolutely wild, and some of it is kind of stuff you've probably heard, but I haven't gotten a chance to talk about. And yeah. Someone says mispronounced name. It isn't Monday. Did you get lost on your way to play some RimWorld? I haven't played RimWorld in a while. I've been playing a lot of Hitman. Good to see the tie. Lets me know Dad and Daddy are getting. We were not fighting. We were not fighting. And Kathy Perizzo says the boom gets a super chat. All right, we can make, if people want to make that a thing, we can make that a thing. So, what is one of the first things? Well, something that would normally be kind of boring, which is the addition of another lawyer, is not at all boring in this particular case because that new lawyer is Mr. Betterow. So he is coming on the file. He is coming in hot, and that is really, really interesting. That is, so now there's this huge team. They've got 5 lawyers on this, and it is kind of crazy. So for the people who watch like the Young Jerks, you're going to miss out on seeing Mr. Betterow there, but because now that he's on the file, he's not going to be able to do sort of commentary on it and so forth. But it's going to be amazing. Somebody says, have I heard of these lawyers before the court case? No. I've just been really impressed by them during the court case. So that's its whole sort of separate thing there. All right. And Stephanie says, thanks for coming on last PM. We love you. Thank you. I was really glad to be there. It was lots of fun. So yeah. All right. Let's cover the super chats here quickly so we're not super behind. Teacup Kraken, thank you for becoming a YouTube member. Peyton Weismiller, I've been a member for a full-term pregnancy. Well, thank you. That's a weird way to put it, but okay. Excuse me. Happy Thursday. Boom. He means 9 months, but I don't think he's actually, well, I could be a she. I don't know. Chop Trials, life advice from Runkle in 3, 2, 1, boom. I don't know if boom is life advice. Jen DeCimio, thank you for the membership. Much appreciated. Tyranny, long time no live, but I'm back. Thank you, Replay Runkle, for keeping me sane. Thank you for being on replays. I appreciate everyone on the replays too. The only downside to the replays is that I do turn ads on. So if you're watching on replay, you'll get the ads. I see it's a she. Okay. Maybe there's actually a thing there. So the Pilgrim Shadow, boom. Thank you for the bonus stream. Thank you for being here. Mispronounced name. Oh, we covered this one. Kathy Perizzo, the boom gets a super chat. And Melissa816, thank you for the new YouTube membership. Much appreciated. Okay. So, there are so many things. Turtle Boy filed a motion to dismiss today. I don't have that yet. I don't have Turtle Boy's motion to dismiss yet. So that, I guess, is another thing. So many things. Okay, where do we start? Let's start with the Commonwealth doing some stuff that I think will probably annoy many of you. And yeah, I mean, they're allowed to do it. They're allowed to sort of do all that. Linda Santiago says, thanks for a bonus stream. Thank you. Tony P, thank you for 5 gifted memberships. Much appreciated. So here's what they're trying to do. They are trying to throw out the ARCCA reports and the ARCCA employees. So, and Gen X Chick, thank you for the membership there. Much appreciated as well. So let's talk about that first. We're probably not going to talk about things in order of filing. We're going to talk about them in order of my attention deficit because that's how we roll. We're just going to do that. So here's where we start. Commonwealth's motion to Commonwealth's motion for to exclude okay, employees of ARCCA LLC. For to exclude is interesting. The Commonwealth moves to exclude the defendant from calling employees of ARCCA LLC, including but not limited to Daniel Wolf, PhD, and Andrew Rentschler, PhD, due to the defendant's failure and inability to comply with discovery obligations under Massachusetts Rules of Criminal Procedure 14. As revealed during the defendant's first trial, Dr. Wolf and Dr. Rentschler were 2 experts retained by the federal government in furtherance of the U.S. Attorney's investigation of an unspecified federal crime. Both Dr. Wolf and Dr. Rentschler admittedly did not review all pertinent and relevant evidence that exists in this case, asserted that they did not speak with the defense prior to their testimonies, and conducted experimentation and analysis that exceeded the facts and evidence in this case. Nonetheless, the court permitted both Dr. Wolf and Dr. Rentschler to testify on behalf of the defendant in June 2024. And I don't think that's likely to change, right? I don't think that the judge is going to reverse her decision on this. So the parameters of the expert's opinion were not provided by the defendant prior to her first trial, and portions of the expert's opinion were not expected nor properly noticed. Furthermore, during the first trial, Dr. Wolf and Dr. Rentschler testified to reviewing information that was not known prior to rendering their opinions, and this was not previously disclosed to the Commonwealth. So basically, they're saying, we didn't get all the information, and I'm being told we need a goal. Okay, let's say goal. What sort of goal should we set here? Let's see. Uncle discusses. We'll put this one. Something I'm trying to work on and could tell you about if we hit the goal. Okay. So now this might be things like I just saw in the chat. I saw somebody mentioning the canon. It might be that the canon is one of the things that they're saying was not properly disclosed, that they didn't tell us about the canon. Now, by the way, for the people who are still saying that Brennan hasn't watched the first trial, Brennan has to have watched the first trial at this point if he's making these arguments, or he's relying solely on Lally, which would be crazy. I think Brennan has watched the first trial at this point, or is watching it, right? So, but the thing is, they're saying you didn't tell us everything that the expert knows. Well, the thing is that the defense only is required to turn over information that they know. They can't turn over information they don't know. So, Citing a restraint and inability to comply with Massachusetts Rules of Criminal Procedure number 14, the defendant failed to provide the Commonwealth with any discovery from ARCCA, LLC, Dr. Wolf, or Dr. Rentschler. All right, let's just pull up. I didn't do this beforehand. I really ought to have. We're just going to pull up Massachusetts Rules of Criminal Procedure. Pretrial discovery. Now, are they just saying Part 14, or are they saying Part 14.1? Let's see. All right, let's see what the mandatory discovery is for the defense. We'll just pull that up right there. Boom. Boom, boom, boom. All right. So the what is it? Reciprocal is they have to provide everything. I'm just looking here. Anything special? Okay. Any written or recorded statements. This is what the prosecution has to provide, but the defense has a rule to provide basically a lot of the same stuff which they want to provide. Intended expert opinion evidence other than evidence that pertains to the defendant's criminal responsibility and is subject to subdivision B2. Such discovery shall include the identity, current CV, and a list of publications of each of the intended expert witnesses, and all reports prepared by the expert that pertain to the case. That seems appropriate, but I don't see how they couldn't comply with that. I mean, are they saying that they didn't provide a CV? What are they saying? Okay. To allow the defendant ample time to retain her own experts and to prevent any delays in the April 1st, 2025 trial date, the Commonwealth renewed its request for discovery, enumerating 13 areas of discoverable materials related to ARCCA from the defendant. On January 6th, the Commonwealth notified the court and the defendant of its intention to move to exclude ARCCA based on the defendant's repeated failure and inability to comply with the rules. To date, the defendant has filed no response nor produced any additional discovery. I'm guessing they don't have it because they work with like the FBI. On February 6th, Attorney Jackson indicated to the Commonwealth and this court that he intends to call experts from ARCCA, presumably Dr. Wolf and Dr. Rentschler, at the defendant's upcoming trial. On December 4th, Commonwealth filed a written request for discoverable material. Commonwealth and defense received a response from the U.S. Attorney's Office citing certain federal statutes and regulations that restrict the complete discovery the Commonwealth is entitled to. So they're basically saying we're not going to provide, they're saying you can't call this witness because the government refuses to turn it over. And it's like, this is the federal government refusing to turn it over to the Commonwealth government. But if the government is unwilling to turn it over, then the defense doesn't have it. So peculiarly, despite the formal 4-page letter received on January 30th, following the party's appearance, the Commonwealth and defense received an email from the U.S. Attorney's Office stating that their contract with ARCCA LLC ended on July 31st, and should either party wish to engage ARCCA LLC for additional analysis, any further engagements must not infringe on any federal privileges. Okay. Yeah. Massachusetts rules demand reciprocal and expert discovery. As the proponent of the evidence, the defendant bears the full obligations of Rule 14. And so that provides for an automatic exchange of discovery regarding intended expert evidence. The defendant cannot shield herself from discovery obligations by citing restraints by the U.S. Attorney's Office, or by now perhaps claiming to have independently retained ARCCA for additional analysis and producing only a limited portion of expert discovery. So they're saying, we didn't get all the reports, we didn't get all the things. And the thing is how are they going to provide that? So the argument that Brennan is making is they can't provide all this stuff because the federal government won't let them, and therefore it is, that they can't comply, so you have to toss these experts out. I don't think that the judge is going to go with that, but it's possible. It is possible. So we'll see. Let's see. All right. I am just trying to work out a last minute tech glitch. That's lovely. All right. Let's see. Okay. Why is this causing problems? Okay. Here we go. So, they say the Commonwealth has diligently sought expert discovery from the defense and U.S. Attorney's Office for approximately 10 months. A second voir dire is not an appropriate remedy, as the defendant has continued to sidestep their discovery obligations. So they're going to say, previously, I think that that the judge got around this by saying you can question this witness. The Commonwealth is entitled to a fair trial and simply has sought what every criminal defendant in the Commonwealth of Massachusetts is obligated to produce. The Commonwealth is not entitled to is entitled not to repeatedly be ambushed at trial and be permitted to effectively prepare for cross-examination of any witness. You have an entire prior trial, right? You have an entire private trial at this point where you that's better than usual discovery. So yeah, strategic decisions do not alleviate a defendant from discovery compliance, and after 10 months, the only appropriate remedy is exclusion. I don't think it's a strategic decision. It's just that this is how things worked. So, and they cite to Commonwealth versus Drunka. Criminal defendant's constitutional right to call a witness on her behalf is not absolute, may be limited in the judge's discretion in the face of legitimate demands of the adversarial system. Okay, so that is a fairly brief thing, but basically what they're saying here is, yeah, you can't turn over this stuff, so therefore we need to exclude those entirely. And that is a big, big problem here for all of this, because it's like, well, how do we, how do we do this? So, all right, I'm just getting sent stuff last minute, and then I'm trying to figure out, if it's something we need right now. All right. So, let me just see here. Okay. I'm just trying to figure all this out because juggling things that I'm getting sent last second, and we're trying to see what we can do. Okay. All right. Let's see. Okay, so that's our first thing. Sorry, I'm juggling stuff. I'm getting sort of thrown off a bit. So that is the first thing. Now, what is my prediction on this? I don't think Judge Canone throws it out. I don't think she does, because ultimately that would be a bit of an issue there. But it is possible. I mean, it is potentially a possibility. I don't think that this argument is insane. I would make this argument too if I was in Brennan's shoes, because I'm sure he very much wants to keep the ARCCA guys out. And if he keeps the ARCCA guys out, then, Karen Reed's chance of getting convicted goes way up. But I think it's interesting that I mean, they're upset about they're upset about the discovery when they're still turning over video footage that they didn't have for the first trial. And I'm like, that's a whole thing when they didn't turn over video footage from the first trial. And then they go and they're like, well, that's not a problem. We shouldn't throw this case out because of that. But the other thing is, like, how does defense turn over something that they don't have? Certainly, that would be the argument that they're making in their own, case. They're like, well, we can't turn over this video because we don't have it, right? We don't have it at all. And like they ran with Trooper Paul, they ran with all of this stuff, and we're going to see an expert they want to bring to the table in just a second. That's what we're going to cover next. And you can see that, like, the expert they're bringing to the table, how do I put this? They're not sending their best, is the way we're going to put this, right? Is that they're not sending their best. So, because this is going to drive me nuts, we're going to crack open a drink here, because we're going to talk about who they want to testify about bitey doggos, and the absence of bitey doggos and so forth. That's their argument. And yeah, basically the prosecution's argument is that because the FBI won't play ball and provide everything because their investigation is still confidential and whatever, that the defense can't use them. And that is, it's a bit crazy. So, what is it? Let's talk about sort of the next thing here. And that is, boom, tiny. Let's make that a little bigger. Okay. Motion of the defendant to exclude the testimony of the Commonwealth's witness, James W. Crosby, MS, PhD. Okay. Now comes the defendant. God, I hate that. Karen Reed, Ms. Reed, and respectfully moves this honorable court to exclude the testimony of James W. Crosby, MS, PhD, concerning the medical cause of injuries to the right arm of the decedent, John O'Keefe, the decedent. Exclusion of the testimony is compelled because it fails each of the two prongs of the Dauber-Lonergan inquiry, qualifications, and methodology. That is, Dr. Crosby is not qualified to render the opinions he proffers. It is undisputed he is not a medical doctor. Now, keep in mind that this one is kind of using Judge Canone's language against her, because previously with the ARCCA guys, she had allowed the ARCCA guys to testify in part, but she had also said that she wouldn't allow them to testify entirely. Like, she would limit their testimony specifically because, wait for it, they were not doctors, and that in this, in Massachusetts, that you need to be a doctor to testify as to the causation of injuries. So, they're saying, okay, well, because you need to be a doctor and you already said that, then you need to still be a doctor, right? So, yeah. All right. So, let us continue. So he thus fails, per se, the crucial qualifications inquiry of the Dauber-Lonergan standard. This failure is not curable. I mean, it could be curable. It could be. All it takes is for Dr. Crosby to just do a little thing in between now and trial. He's got 2 months? He's got 2 months to fix his problem. And you know how he fixes his problem? He does an entire medical school in 2 months. If he can do that, then he can solve this problem. TikTok, motherfucker. Get on that. Yeah. I I will be impressed if he manages to pull that off somehow. Then I will believe that he is qualified. Because yeah. All right. In addition, the methodology that he invokes in his report is not reliable. Among other defects in his methodology, there is no showing that it is generally accepted in the relevant medical community, and the methodology is replete with errors, as is demonstrated in the affidavit of Marie Russell, medical doctor. And you notice how they put medical doctor in, in there, because it's like, oh, right, our expert is actually a medical doctor. Their expert is some clown. He's not actually a clown. He's got like a PhD, but he's got a PhD in the wrong thing. And she's like, I'm the medical doctor. So, which is submitted in support of this motion. Now, if you're wondering, isn't that name really familiar? Yes, Marie Russell is the defense dog bite expert. Now, we're going to run into a bit of the same problem with this as we got with, as we had with, the motion to exclude Dr. Green, which is the argument cannot come down to just that we disagree with the opinion. Because if it comes down to we have a different opinion, then it's going to fail for the same reason that the motion to exclude Dr. Green failed. Failed hard, right? So, yeah. The failure of either Dauber-Lonergan prong requires exclusion of the proffered testimony. Dr. Crosby fails both prongs. So basically, the defense only needs to win on one of these points in order to exclude this evidence. And we have hit the goal. I should start another goal. Let's see. What should I put as a goal? Doggo video. We're going to put a goal for a doggo video. All right. So argument. The Commonwealth fails to and cannot meet its burden to establish the requisite qualifications of Dr. Crosby. By the way, the doggo video, if you watched me on the Young Jerks, you will have seen the doggo video, but we're going to play the doggo video here too. I have not yet made it into a proper swoop, but we can do that. So, the crucial issue in Massachusetts for a Dauber-Lonergan inquiry is whether the proffered witness is qualified to give an expert opinion regarding the subject matter of his testimony. Why does this matter? Well, I mean, if you want something where it's like, hey, we're going to call somebody to testify about, like, a head injury, right? This person got hit with a brick. Did that hitting them with the brick cause the brain bleed that ends up, did that cause them to die, right? That's medical information, right? That's medical details. And so who do you need to testify about that? Well, you need like a doctor, like a coroner and so forth. Let's say you are trying to determine, let's say there's a car accident, right? And at the time of the car accident, it is undisputed that the car was driving like as fast as the car can possibly go. Now, the argument that might come up at trial is the defense says, listen, my client was not like hammering his foot to the pedal and driving like an idiot. This vehicle had a failure that caused it to maximize the gas pedal, even though my client's foot was not on it. And, then the vehicle drove and crashed into somebody else and killed them, right? It's not my client's fault because vehicle failure, right? Or the brakes failed or whatever else, right? Who are you going to bring as an expert in that? Well, maybe some sort of, maybe a qualified mechanic, maybe, whatever, but you're not going to be able to bring some guy who, his expertise is, I sometimes like fixing cars in my backyard, right? That's not a qualification. It might be that he's actually the world's best vehicle savant, right? But it's you still got to have some actual qualifications, right? You got to have some basis for it. So yeah. All right. So yeah, are they qualified? The subject matter of the testimony of Dr. Crosby is as described in his self-styled preliminary report dated January 24th, 2025, is the medical cause of the injuries and wounds to the right arm of the decedent. So what we already know what he's there to testify about, right? He's there to testify about the injuries to John O'Keefe's arm, which to me looked like a dog bite, and to the prosecution look apparently like a vehicle bite. Now, I don't know about you, but vehicle bites don't seem to be a thing, but they're saying, yeah, this is a thing. Yeah. All right. On June 18th, 2024, this court was clear and emphatic in its statement about the foundational qualifications a proffered witness in Massachusetts must possess before he or she can opine on the medical cause of an injury to a person. Such person must be a medical doctor. Specifically, on that date, Your Honor ruled. Remember how I said they were kind of using Judge Canone's language against Judge Canone? Right? Remember how I said that? Remember how I said that was totally a thing that they were doing here? Well, now they're doing it really, really explicitly. And this is always great because you can kind of pin the judge down. Because now if the judge wants to rule against you, the judge has to be able to express why this is different than the time they ruled before. And they noted, Dr. Rentschler, though, I have some concerns. It's clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. So I'm going to reserve ruling on the rest of his testimony. There are certain things he can testify, and I'll hear you again before he testifies next week. Let's just proceed with the trial today. So the specific quote that they're noting there is, it's clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. So basically, they're saying, you said only an MD can testify about causation of an injury. This guy is not an MD. Therefore, you're out. And Helfligan says, even though the MD said you'd need a biomechanical engineer. Yeah. So Dr. Crosby fails this rule of law stated by Your Honor. His failure cannot be disputed. Dr. Crosby's report and his accompanying CV clearly show that he's not a medical doctor. Rather, these documents demonstrate that he merely possesses a Master of Science degree from the College of Veterinary Medicine and a PhD in Veterinary Medical Science, both from the University of Florida. Neither of these are or even come close to a Doctor of Medicine MD degree or being a licensed medical doctor. Nor is he an odontologist or Doctor of Veterinary Medicine. Now, I don't know what veterinary medical science is or a Master of Science degree from the College of Veterinary Medicine. And you know who else doesn't know what those are? Dr. Marie Russell doesn't know what those degrees are. So, because Dr. Marie Russell is going to be like, those degrees don't even go to this school. I don't know how they got here, right? So, yeah. Moreover, Dr. Crosby concedes in his report that he's not a medical doctor, stating, I am not a physician. Dr. Crosby then appears to express awareness of and sensitivity to this failure of qualifications. He unsuccessfully attempts to evade this shortcoming by raising a straw man argument that he should escape this failure because this case is not about the treatment of the wounds on the right arm of the decedent. There, in his report, he states, "I am not a physician." Okay, end of matter. Everybody go home. I am not a physician. I am not licensed to treat injuries or illnesses in human patients. Is he licensed to treat injuries or illnesses in animal patients? Maybe. But it is about human injuries, right? Because I don't think it's in dispute here. I don't think it is at all in dispute here that John O'Keefe is a human, right? So he's not licensed to treat injuries or illnesses in human patients. We're dealing with a human. So, why are we still here? However, this case is not about the treatment of victim John O'Keefe's injuries or wounds. It is about the analysis of them, though. Thus, any opinion regarding the medical treatment of Mr. O'Keefe is inapplicable to the issues at hand, irrelevant, and has no impact on my opinions or for the opinions that have been asked of me in this case. So the unilateral manufacturing of a treatment issue out of nowhere by Dr. Crosby, I don't know that they ever actually attempted to treat John O'Keefe's arm injuries, because I would be surprised if anybody even so much as has like gave a shit about his arm injuries during the time. Because if you've got a guy who is dying, I mean, those scratches are real bad, right? Those injuries on his arm, the bite wounds are real bad. If I had injuries like that, and I went in, I would expect that they would give me stitches, B, probably give me a tetanus shot, C, ask, hey, did you capture the dog? Because we're going to need to do rabies shots. But the thing is all of that stuff, like if you need stitches, but you're like dying, they will worry about the dying first, right? And so the arm injuries, they're nasty. They're things that would have like severe, if there were no other injuries, they would have severe cosmetic issues. They would, they'd be like serious injuries, but they're not going to kill you, right? If you didn't get treatment on those, unless there was rabies at play or some sort of infection, some sort of biological, bacteriological, viral agent, going on there, you're not going to die from that, right? So yeah. And we are at 4 out of 10 super chats necessary for the doggo video. So yeah, Celine says they might not have even seen the arm injuries through John O'Keefe's coat. It's true. Yeah. All right. So I don't think that they applied any treatment. I would be shocked if they applied some sort of treatment for that. So yeah. First, the defense has never mentioned any treatment of the decedent. Yeah. Or sorry, the unilateral manufacturing of a treatment issue out of nowhere by Dr. Crosby is flummoxing and nonsensical. Flummoxing. That is a great word. I love flummoxing. First, the defense has never mentioned any treatment of the decedent. Defense witness Dr. Marie Russell rendered opinions about the medical cause of the wounds to the right arm of the decedent. She did not render any opinion on treatment because there probably wasn't any treatment. Second, the fact that this case is not about the treatment of the wounds to the right arm of Mr. O'Keefe cannot save Dr. Crosby from his lack of the requisite qualifications, nor can it be allowed to camouflage the fact that the import of Dr. Crosby's entire report is him opining on the medical cause of the wounds to the right arm of the decedent, something he legally cannot do in the Commonwealth of Massachusetts. In this regard, his report states, Dear Mr. Brennan, this letter is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Defects, by the way, is such weird language. And Dr. Russell is going to call out the language of defects. Like a defect? Are you sure? Like really defects? Aren't we talking about injuries? We're talking about wounds. We're talking about that. We're not talking about defects. It's not like he was born with odd, injury, like odd, it's not like he was born dog bitten, right? That wasn't, it's not like that. So, yeah. Defects just seems weird to me. So I was asked to examine the evidence in this case, including images, reports, and the involved dog itself, and determine, if possible, the potential source and nature of the defects documented on the right arm of decedent John O'Keefe. I was particularly asked if I could determine, to a scientific degree of certainty, whether those defects were consistent with a dog bite or other animal bite. Here's the fun thing. Here's the real fun part of this, is that they are playing a little game here. They're playing a little wee little game. And the wee little game that they're playing is they're saying our expert had access to the dog. Their expert did not have access to the dog. And so what they're going to do at trial is they're going to say, you shouldn't believe Dr. Marie Russell because she didn't look at Chloe. Our expert looked at Chloe. Our expert is so much better. And our expert really, like they just can't solve this problem. And, right? You see the trick they're doing with that? You see the move that they have planned for the jury, right? So that's where they're going on this. All right. The issue presented to me in this case is isolated to the nature, morphology, and likelihood of association between the defects documented on the right arm of Mr. O'Keefe, and as to whether these defects are consistent with, to a reasonable degree of scientific certainty, a bite by a dog. Particularly a question is the likelihood of those defects being attributable to a German Shepherd type dog known as Chloe, who resided at the time of this incident at the residence near where Mr. O'Keefe was found, or by any other potential large dog alleged to be in the area. And Raven 254 coming in with this. Saying, can I just send one $50 super chat rather than individual $5 chats to reach the goal? I want to see the pups. I think we can say that goal has been met with that one. Let us... all right, let me pull up a video because somebody very much wanted to see the doggo. And I mean, I get it because it's a good dog. Let's see. Here we go. Here's the dog.
Hey, buddy.
So that's what is it? That's me in in a hammock there, and Potter is like, "Hey, I'm gonna come up, and I just wanted like Potter just came up, and he wanted to be near me when I was in the hammock, and he's like, I want to hang out. And so he was there. He's like, I could have some pats, I could have some pats." So he was being a real sweetheart. He was, and so the one thing that disappointed Potter when that whole adventure, by the by, that Potter was not super happy about. Potter tried to get into the hammock with me. Now, Potter is a big boy. Potter weighs like as much as I do. And so when Potter was like, I could climb into the hammock too, right? I was like, no, buddy, you cannot. We will die. And somebody said, "Is Potter the bigger of the dog? Two dogs?" Yes, Potter is the bigger puppy. So he's a big boy. Potter is not a small little pup, and yeah. So let's see. Do I have a Zora video that I can play that would be a good Zora video? Because we need another goal now, and I think I've got one. It's got me talking with some other people who. All right, I have confirmed that this is a safe Zora video. I'm gonna move it over. We will get it ready to play here, and then I can put that up for a second goal because goals are good. It's good to have things to aspire to. I see somebody says bigger hammock time. Okay. Start another goal. Zora video. All right. You will hear some of a friend of mine, but very little. Oh, Celestial Heather, I do have the pictures. I can go run and get those in a second. We'll maybe set that as another goal. Maybe. So Dr. Crosby attempts to opine that the wounds on the right arm of the decedent cannot be caused by Chloe or any other large dog. Thus, his straw man discussion of treatment of the decedent is a distraction, is very much beside the point, and it fails. So Dr. Crosby's venturing well beyond his qualifications in attempting to make the sweeping determination that the wounds on the right arm of the decedent could not have been caused by Chloe or any other large dog is also illuminated by his own proclamations. That sentence is awkward. That sentence is clumsy. I don't like that sentence. If I'm the lawyer reviewing this, I am putting some red ink on this and I'm going, rephrase, but it is what it is. That's a stylistic thing. We will get to the flamethrower story. I will not cheat you out of the flamethrower story. It's just that we had the large super chat, so I was like, we're going to interrupt with the doggo thing. Okay. The Zora video is actually fairly stationary because Zora, when she's in motion, is a blur. All right. The name of his consulting group is Canine Aggression, and the vast majority of his experience points to canine behavior. Additionally, Dr. Crosby's purported title, Certified Behavior Consultant, also underscores what is already evident. He does not have the requisite qualifications to opine on the medical causation of an injury to a human. I.e., this is a guy who studies what makes dogs bitey, right? He's like, if dog is bitey, why is dog bitey? How do you stop the dog from being bitey? Also, hey, recovery addict folks, that is great to see you. So basically, he's saying this guy's an expert in how to make your dog not bitey. And yes, somebody, Vomit Fountain in the chat saying, so he's a glorified dog trainer. That does kind of seem like where we're at here. So the Dr. Russell affidavit also discusses the lack of qualifications of Dr. Crosby. We're going to get to that affidavit too. We're going to do the flamethrower story in between, but yes, we will get to that. Accordingly, because Dr. Crosby is not a medical doctor and thus cannot meet this court's medical causation prerequisite holding of the need to be a medical doctor pronounced on June 18th, 2024 during the first trial, Dr. Crosby fails the crucial qualifications inquiry as set forth in Rintala. By the way, here's the fun thing. Let's say the judge rules that this guy can testify, right? That this guy is allowed to testify, notwithstanding that he's not a medical expert. Well, what is the defense going to turn around and try to do? They're going to turn around and say, listen, then our ARCCA guys get to testify as to the causation of this injury. They get to testify that this injury, the specific injury on John O'Keefe, was not caused by a vehicle. And you know how bad that is? So, yeah, they're kind of putting Judge Cannone on this thing where she either has to rule one way that benefits the defense, or she rules another way that benefits the defense. And yes, this is the kind of thing, by the way, you really want to do when you're a lawyer, is you want to give the court situations where it's like either you rule for me or you rule for me, and there's no other option. Either it's good for me or it's good for me, and there is no bad for me option here. So, yeah. So any testimony from him thus must be excluded from the upcoming trial on this basis alone. The court need not reach the other prong, methodology, of the Daubert-Lanigan inquiry to exclude Dr. Crosby, because the failure on the qualifications prong alone dooms him. Doom, doom, doom. However, if the court proceeds to the methodology prong of the Daubert-Lanigan inquiry, the proposed testimony of Dr. Crosby fails on this point as well. So this is an alternative argument, right? This is, if I should win on this, right? I should win here. But if I don't win on this, then I should win on this other thing. And so basically they're saying that Judge Cannone has to rule against them on both points in order to rule against them on the ultimate issue. So the Commonwealth fails to meet its burden that the methodology of Dr. Crosby is reliable. So neither Dr. Crosby in his report nor the Commonwealth elsewhere meet their burden of establishing the acceptance of the methodology employed by Dr. Crosby or the reliability of it, nor can they. So let's consider acceptance of the methodology, right? So let's say I have a medical expert, right? And the medical expert comes on and they say, they get up on the stand in a voir dire about whether they should be admitted. And they say, this person was definitely shot. Colonel Mustard was shot in the kitchen, with the handgun, right? And so, okay. So a doctor should be pretty qualified to say that somebody was shot, right? And maybe this person has, every bit of experience in gunshot wounds. This person has testified at trials involving gunshot wounds millions and millions of times. They have, they wrote the book on it. But in this particular case, it's like, how do you know he was shot? What tells you that he was shot? And he says, well, I got out my Ouija board and I put my hands on the little Ouija board thing and it went to, I was shot. And that's his methodology, is the Ouija board. Well, here now we're running into a problem because this person might be qualified, as in they have the qualifications, the expertise to identify a gunshot wound, but their methodology in that circumstance would be dog shit because Ouija board is not recognized by any scientific discipline as a reasonable way to do wound analysis, right? It's just, yeah. So that sort of illustrates the distinction there. And I see somebody saying, lol, it's a planchette. Yes, I know it's a planchette, but I didn't want to use the word and have people go, what's the word? So, yeah. So the Dr. Russell affidavit provides details regarding the incorrectness, flaws, and other unreliable aspects of the methodology employed by Dr. Crosby, including his application of the methodology. Now, here's the problem, is if they're getting into the application of the methodology, then we're into a problem because they really need to not get roasted on their own argument here, because they're running the risk of getting roasted with their own arguments. The problem that they may run into is that if I was Brennan, let me tell you, if I'm Brennan, I am stinging. I am hurting from that last close. that came up. Let me. I did a little. I did a short on it, and I think I can run that short. Where's that short? Where is that short? Do I have the short? Is this the short?
Uncle the Bailey has been nominated.
Nope, that is not it. Where did I put that short? I had. Here it is.
Say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your
Okay.
Honor. Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Galbraith hearing. Thank you, Your Honor.
All right.
So I had that little I had that short, and the thing is that Brennan has got to be stinging after that 60 seconds, right? And that he got it done in 60 seconds, including Judge Canone's sigh. But like Brennan's got to be just like hurting over that one, and so he's going to be looking for a chance to sort of clap back on that one. And you know what he's going to say is, listen, they said it was only an opinion, and here they're arguing the opinion as well, right? That's what they're doing. So that's going to be what they have to avoid. Let's see how they do on this, right? So, all right. So these include his erroneous wound directionality theories and other aspects of his wound discussions, lack of proper forensic foundation and protocol regarding photography of the wounds, and failure to properly consider canine DNA related shortcomings of the Commonwealth and its agents involved in the DNA process. So some of this, I think, is issues of we don't think his opinion is very good. Other things are issues of his opinion is sloppy. I don't know that they're going to win on this point. I think that if they win on this, I think if they win on this motion, they're going to win it on the first issue, not the second. That would be my bet. And I think Judge Canone has shown a preference. She's shown a preference overall for letting expert evidence in. Michael J. Money, Runkle, as an attorney, ever burned you like that in court? Not exactly, because it wasn't using my words against me like that, but I did have a lawyer get to dunk on me because my client sucked. Yeah, I think if they win on this, it's on the first prong, not the second. But we're going to cover the second prong because it's a large focus of Dr. Russell's affidavit, and because they're arguing it, right? So the Dr. Russell affidavit also discusses the failure of Dr. Crosby to adhere to medical norms by deeming his report preliminary. He's like, it's just a preliminary thing. And I see Greg says, EDB said Alessi is really good at putting his winning arguments up front and his weaker points at the end. I agree with that. I usually would recommend, what I would say is leave your weaker points out. Usually you do better if you have like 2 strong arguments rather than 5 total arguments that are 2 strong and 3 weak arguments, right? But here, I think they do have to argue both, and I do think it is very sensible of them, as EDB noted. I think it is very, very sensible to for them to say, "Listen, we're going to put the we're going to put the argument on his qualifications first." I see somebody saying, "Are you going to stream the hearing Wednesday?" Probably. All right, so. On the jurisprudential front pertaining to the Dr. Crosby report, the defense's legal research did not discover any relevant Massachusetts state cases on the admissibility of bite analysis by a non-medical doctor, specifically regarding dog bite wounds inflicted on humans. The inflicted on humans is a key point, because I suspect one of the things he may say, if he's called to a voir dire, is he may say, "Listen, I have dealt with dog bites on other dog bites, right? On other dogs, right? Because dogs bite dogs all the time. It's a really common veterinary injury, right? Dogs biting other dogs. When we had Ripley, and so my first two dogs were Ripley and Paddington Bear. We got Ripley first, and then we got Paddington Bear. And so Paddington wanted to be in charge when he got there, and Ripley was already in charge. Ripley was like, "This is my house." And then Paddington came in and is like, "Hey, I am a bigger..." Paddington was kind of the German Shepherd, mostly. And so Paddington is like, "I want to run this show." So Paddington and Ripley got into fights a couple of times. And when they got into fights, they bit each other, and it was insanely expensive because dog bites get expensive. But you know what the thing, there are various things about dogs that are different than humans. You might notice if you see a dog, like, when we see, for instance, this dog, he is very cute, right? Very, very sweet. Unlike humans. Humans don't look this good. Humans don't look this cute. And you will see that he's got like great big chompers there. But the other thing, that you will notice that differentiates this dog from, your average, human, is that dogs have fur. Lots of fur. And also their skin sort of functions a bit differently. One of the things the vet explained that happens a lot, and like when I took the dogs in, they actually said this is a big difference between dog bites to dogs and dog bites to humans. The vet actually told me this one. They said, "Hey, this is something you got to know." And they were the reason why they said that they had to tell me this was to explain why it was going to be super expensive to get this dog bite treated. When a dog bites a person, human skin is very soft, right? And it tears easily. And so when a dog bites a person, they tend to rip their teeth through the skin, right? And you get those like raking bite marks, right? Whereas when a dog bites another dog, their skin is tougher and furrier and so forth. So the dog bites and grabs skin and leaves puncture holes, and then it pulls. And sorry, folks, this is going to be a little bit graphic. And instead of it like pulling through the skin, it actually pulls the skin away from the flesh. And they get these injuries where it's only a little small puncture on a dog, but because of that pulling, it's actually caused the fur to pull away from the flesh underneath. And so they essentially get like a degloving kind of injury where they get this, fur that's it's no longer attached, and it's a big problem. And so that only happens when dogs are biting other dogs, as opposed to when dogs are biting people, where it tears through. They're very different bites, right? They're very different styles of things. So when somebody tells me I'm an expert in dogs biting other dogs, I go, cool. I don't see any reason why that would look the same or be the same as a dog biting a person. It's a different thing, right? And, if you're just wondering, like, how could this, Runkle, what you're saying makes no sense. I just want you to consider the two different things that will happen if you bite into, like, a strawberry versus if you bite into, like, a football, right? Or like a watermelon, right? Different things you bite to are going to have different sort of patterns and different sort of marks and different sort of, different sort of injuries. So the long and short of this is that when they say they can bring in this guy who's a veterinary medical expert and talk about dog injuries, I go, can you though? Because, and I mean, like, here's a can of pop. I'm not going to leave the same injury on that as I would biting into like a piece of pizza or, a grape. So, yeah. This is kind of the key thing there. All right. So the extra-jurisdictional cases are those involving human and not dog bite matters, and proffered experts who are either forensic odontologists, practicing dentists, or professors with like credentials. The other thing that happens as well is that is that people people bite people all the time. People bite people all the time. Big Vaughn, another grifter, he says. So we got a troll in the chat. Big Vaughn, it is something really telling. Because you're here, because you want to play your game, I'm going to dunk on you. It is something really telling that the anti-Karen Reed side does not have a single lawyer supporting them. It's really telling that not a single person is standing up for you. It is really telling that so many of you, when it comes down to it, turn out to be related to the people involved in this case. And I know you're not going to admit that, but I suspect that is you. And if you want to continue to play here, the price for you to continue to troll here is going to be $20. So, Big Vaughn, if your next message is not a $20 super chat, y'all can go away because you're just here to troll. And if you don't believe in your cause at least $20 worth, then, yeah. That's the troll toll. You can pay the troll toll or y'all can go away. But really, wouldn't it be nice if there was some lawyer out there that you could give those super chats to because they're supporting your cause? There isn't, because not a single lawyer has wanted to get on YouTube and to publicly say, hey, I think that that their case is a good one, and I think this was a good investigation. And the reason why is because they are worried that they would lose credibility as a lawyer if they said, hey, this was a good investigation. No lawyer is going to get up and say this was a great investigation because they would be clowning themselves. So you got no one in your corner. You are here trolling me because you have no one in your corner. And the fact you are here to troll me indicates just how alone, just how isolated your argument is, and that it's really just you. Yeah. So, you're here to troll, but you are embarrassing yourself, and you are embarrassing your cause, and you need to stop it. Yeah. All right. So, as mentioned, what comes up a lot in cases is human bites on humans, right? Human bites on other humans. Because when people get into fights, they often bite people. This happens a lot in bar fights, that people get bitey. Like if you're wrestling, if somebody's getting like choked out, for instance, if you've got somebody who's doing a choke, right? Somebody is, or somebody's like trying to strangle you, they might go and bite down if they can get a hold of it, right? Bite in and leave an injury there. They might, people in SAs where, there's where there's somebody like going and like, they either bite defensively or they bite aggressively, right? That is, that's a thing that happens. It's just like it's a common thing. It's a weird thing, but people do that. So, they just, they do that. Yeah. Kids bite. Kids have to be taught, when you fight people, do not bite them. And the thing is, part of the reason why people bite other people is that, I'm going to get a little controversial, is, we're evolved from monkeys, or from a prehistoric ape that evolved into both monkeys and humans, if we want to be a little more, specific. But the thing is, apes have great big giant fangs, right? Apes are really dangerous, and you can actually put a ton of force. Have you ever had something where you're trying to like open a bottle and you can't open the bottle, and you just are like, you know what? I'm going to bite down on it and open it that way. It's because you have so much force in your jaw. It's not as nearly as much as some animals do, but it's still a lot. And the thing is that people bite because animals bite. And the other thing, I'm going to go on a side rant. Do not get a monkey as a pet. And we're going to embiggen myself for the side rant because you don't need the writing there. Do not get a monkey as a pet. And the reason why you should never get a monkey as a pet is because monkeys view you as other monkeys. And this is the worst possible thing, that monkeys see you as a fellow monkey. Why? Because monkeys, if they become a pet, they immediately say, I am part of monkey tribe. Like, I'm part of the little monkey group. And what do they determine? They say, okay, how do I figure out where I stand in the monkey hierarchy? Well, they say, first thing, am I getting laid? And your monkey pet is probably not getting laid because, ew. Second thing is they'll say, am I eating good food? And the monkey will see you eating fruit. They'll see you eating steak. They'll see you eating all of these things. And what they won't see is they're sitting there eating monkey chow. And so the monkey is sitting there and they're like, well, I am the lowest monkey in this monkey household. I am the bottom monkey. And how does a monkey move up the monkey hierarchy in a monkey group? Well, they do that by finding another monkey and beating the crap out of it. And so what they'll do is they'll look around the household and they'll say, which monkey is doing better than I am and that I think I could fight? And the thing is when they say that I think I could fight, it means that they're probably not going to go after the great big, manly man who's in the house. They're going to go after grandma. They're going to go after your child. They're going to go after, the smallest person. And monkeys, when they decide to go fighting, they do not F around. They will bite your face off. They literally chewed the face off a woman who was like, this is my favorite monkey pet. And the monkey's like, I'm going to eat your face. Like, but yes, they quite often, They quite often will attack grandma. They will attack your kids. They will attack whoever they think is the weakest person in the household. Having a monkey is like bringing a tiny serial killer into your house. Do not get a monkey pet ever for any reason, because monkey will eat your face or eat grandma's face, and that is not a good thing. End rant. But yes. Yeah. So anyway, the long and short of this is that people bite each other, and it happens all the time. And then you end up with experts going, hey, is this person's bitey thing connected to this person's teeth? So yeah, that is what the forensic odontologists do, is like, is this a human bite? Like, what is this? So yeah. All right. And this is without getting into a, bite mark identification, bite mark analysis, some of which is discredited, but yes. Okay. So even then, when courts do admit human bite mark evidence on humans, the methodology the experts in these cases followed, those practices recommended by the forensic odontology community, including dental molds and the overlay method, in contrast to Dr. Crosby's self-styled and ad hoc methodology. He's just making it up, right? Which included taking a set of rubber impressions from the defendant's teeth and using the overlay technique, placing a black and white negative of the defendant's teeth over a color transparency of the bite. So, basically what he's supposed to do is he's supposed to make a mold of the teeth so that he's got his own set of Chloe's biters. And instead, what he did is he just was like, Chloe, bite this rubber thing, and then we're going to use that and look at so yeah. And they note, they provide an example case where it's like Brooks versus State, permitting the methodology of Dr. Michael West, a forensic odontologist who made dental casts of 12 suspects and excised the portion of the victim's skin containing the bit marks. At issue in this case is the cause of wounds to the right arm of the decedent, and the undisputed fact here is that Dr. Crosby is not a medical doctor, he is not a forensic odontologist or veterinarian, and he does not appear to have worked with any of these professionals or a medical examiner in any aspect of his process. Basically, he's making it up as he goes along. In other jurisdictions, states that do admit bite mark analysis do so under circumstances where the witnesses involved possessed expertise and the requisite qualifications in forensic odontology and dentists, and many of them worked in conjunction with a medical examiner. Moreover, our research did not reveal any Massachusetts or other case that has admitted testimony or evidence with regard to a dog bite and whether such bite inflicted a wound on a human using Dr. Crosby's methodology, i.e., we looked through all the cases. He says he's like this perfectly normal dog bitey expert, but we couldn't find anybody who does this. Now, I just want to present to you a really, really basic, simple little, little sort of diagram here. So I'm going to put, or I'm not going to if this Sharpie doesn't work. Sharpie, you need to function for me. All right, Sharpie's dried up. Sharpie's in the trash. Let's find another thing. Can I find a thing that'll make a mark? All right. Sort of. Why are all my pens sucking when I need them to not suck? Highlighter. Will highlighter work? Sort of. I don't know how visible it'll be. Okay. So you can see, oh, there, it's real visible. Great. You can see those two lines, right? Imagine those two lines are bite marks from a tooth. Well, now they're further apart, right? You can see and now they're closer together and further apart and closer together. And because skin is flexible, right? And this is going to be a critical thing, is that skin is flexible, skin bends, skin, and, what is it? Now one's higher than the other. Now one's lower than the other, right? And the thing is skin is bendy, right? So, now this is the hand, right? This hand, the skin is fairly tight over the back of the hand, as compared to, like, it's not going to move as much as people are noting in chat. The elbows, your elbow has skin that can, like, because the skin here is like this far away, and now it's this far, right? You can see how, elbow, right? You can see that I'm just holding it in, and you can see the yeah. All right. And somebody says Zora break. Yeah, we can do a quick Zora break. Let us run the Zora video. We'll just do a little interruption. Zora is entirely a non-bitey dog. Zora is
Zora.
Here, I'll mute this. Yes, we'll mute it because there's other people in the background. There we go. Oh, she's such a cutie. Zora was, Zora is just sitting there. She's chilling. She's she's just such a sweet pup. That was filmed. Some friends were over. We had a fire in the backyard, and Zora was just like, I'm going to hang out nearby because I want to be near everyone, but I don't want to be right next to the fire. So Potter, by the way, does not like fires. So when we had the fire in the backyard, Potter is like, he's a distance away. He's like, do not enjoy the fire. So, yeah. Yeah, and Shay B saying, animal skin doesn't stretch like humans. That's why they have extra, and bites tend to be straight in and potentially devastating. Yeah, I mean, I think humans do pretty good on that. So, yeah. Okay. So, Dr. Crosby does not even allege, let alone establish, that his purported methodology is generally accepted in the relevant medical community. This general acceptance concept is a key prerequisite of the Daubert-Lanigan standard and in the alternative general acceptance precept set forth in Massachusetts common law. So, the thrust of Dr. Crosby's report appears to be based heavily on odontology matters, even though Dr. Crosby is not a forensic odontologist or veterinarian. That shortcoming aside for the moment, the scientific community has long questioned the reliability of forensic odontology in a legal context, no matter the qualifications of its proponent. Let's stop here because this was very relevant. Lally and Brennan, both Lally and Brennan, were trying to sucker Dr. Russell into saying something that they could then use to attack her qualifications. What they were trying to do is they were trying to get her to say that the bite marks were specifically to a specific dog, that being Chloe. And she wouldn't say it. She would not do it. Wouldn't do it. And the reason why she wouldn't do it is because that's basically junk science. But here they brought in a guy to say, like, we can totally try to match it to Chloe. So yeah. Yeah. So that shortcoming aside for the moment, the scientific community has long questioned the reliability of forensic odontology in a legal context, no matter the qualifications of its proponent, citing to Brewer v. Hain, stating that forensic odontology evidence has been called into question since the early 1990s. Forensic odontology, if you're wondering what this is like bite mark identification. And bite mark identification has a problem. So what is bite mark identification? Well, let's say you find a dead body, and on the dead body, you find a bite. Somebody bit the dead body, and it's people, right? You can see it's like a human bite. And so then they go and they arrest somebody they think is their prime suspect, and they go and they take a mold of that person's teeth, and they try to see, could that person's teeth, could that have caused that bite? The problem is that forensic odontology has proven to be extremely unreliable for matching specific bite marks to specific people. It's actually pretty good at saying like it matches to a person, like this is a person's bite, but it is bad at matching to a specific human. Now, here's the other thing is that there are circumstances where forensic odontology might be able to make that identification. And the circumstances there are situations where somebody's got some sort of massive unusuality of their bite. And so, for instance, if you've got somebody who's like missing most of their teeth and they've got like 4 teeth, you might be able to say, this is pretty clearly like a match to this guy because nobody else is missing this many teeth, right? Or there was if you've got a case, and good night, Sarah. Good to see you. If there was a case where somebody had, a particular jaw defect that caused, rather than sort of the arc of a jaw, there was like indents in it. And they're like, well, this is pretty specific and is very distinctive. So, yeah. But yeah, basically, I think like tool mark analysis, this is a form of tool mark analysis, and I think most of it kind of sucks. So I set up a goal. Now, guys, I'm kind of going to do this goal anyway, but I'm going to encourage you to hit the goal anyway because, hey, I've been accused of being a grifter, so we're grifting. The grift here, Celestial Heather painted some lovely pictures of the puppies. And I have been owing her showing you guys those pictures. And so I set a goal for, I will show you the pictures of the, of the paintings. And, but I'm going to show you the pictures anyway, but I'm just encouraging you to hit the goal for that. So, and the reason why I'm telling you this is that I'm actually really awful at grifting, because if I'm saying, hey, I'm going to show you the paintings, even if you don't actually contribute the money, I feel like that is kind of counter grifting. It's like, I'm going to show them to you because I owe it to her. But, yeah, there you go. All right. So, the NAS report noted that although some forensic odontologists think that bite marks may demonstrate sufficient detail for positive identification, no scientific studies support this assessment, and no large population studies have been conducted. Even more applicable to Dr. Crosby's report is the fact that bite marks under non-ideal conditions have little published data, and it is unclear if forensic odontologists can identify the origin of these marks under these conditions. Let's talk about biting under non-ideal conditions. So, what is it? Let's be honest, Runkle. You'll never appear in a CoffeeZilla or Scott Schaefer video. It is true. I thought about like starting up a meme coin just as a joke. What it would have been is I would have done a meme coin called Scam. And then I was like, but this could actually hurt people. Like, people could actually lose real money on this. And so I was like, we're not going to do it. The other thing I thought about doing was specifically a project where, for like setting up some NFTs, like, stupid monkey pictures. And I would specifically set them all up on a web page that I would let lapse. And, so it would be like, these are NFTs that will end up linking to either like a 404, or they will end up linking to, or they will end up linking to whoever buys the web page and puts up whatever image at that URL. So, yeah. Lindsay says, would Potter or Zora attack someone if you were in danger? I don't know. Ripley was an absolute sweetheart. And Ripley was such a sweetheart. And we never heard Ripley growl at anybody or have any issue with anybody except for one circumstance. And that circumstance was there was a guy who came by and he was a scammer and he was trying to like run this like scam door to door. And it was the weirdest thing because Ripley was like, as I said, he was just the loveliest dog. He just like, he loved everybody. But that was the only time I saw him full, like, the full, like, mouth drawn back, full on, like, growl. He was mad. And, like, Ripley wanted to hurt this guy. And, so Mrs. Runkle is like, I don't know what this guy's doing, but he's making me uncomfortable. And so she's like, can you deal with this guy? And I'm going, and this guy threatened to break into my house when I told him to get off my porch. He's like, I'll come through your window. And I was like, no. And the thing is if he'd try to come through the window, I would have just let Ripley go. And that guy would have been halfway through the window getting ripped apart by this dog. And it would have been really, really ugly. Now, I would have also been loading the shotgun, but like Ripley would have it would have been over. Like, so this guy threatening to break through the window, I'm like, you have not done the math on this one. So here's the thing. Potter is a real sweetheart. He is a lovely dog. The one time I was out walking Potter and a dog growled at me from a distance away. And Potter immediately just moved and was in between me and that other dog with like a, are you sure expression? He didn't growl. He didn't bark. He didn't anything. Potter just went like, it is business time. I don't know what Zora would do. Potter, I think, would probably, Potter would probably mess someone up if they were coming in to do bad things. And Potter is a big dog. Potter is like you saw, I'm in the hammock and Potter is looming over me as I'm in this hammock. That's me in a hammock and that's his head looming over top of me. Right. So, yeah. I would not want to mess with those teeth, right? I would not at all want that. Because, yeah. What does he weigh? I think he's at like 120. He's a dog. Like he's got some mass to him. So, yeah. All right. Now I was talking about, non-ideal biting conditions. So let's imagine that you've got like, a thing you're going to bite, right? If you are going to bite a thing, you're probably just going to be like, hey, here's the thing. Right? That's kind of ideal conditions. You pick up the thing, you go, and you bite the thing, right? So, but let's say this can of Coke that I'm trying to bite doesn't want to be bitten, right? Let's say it does not want to, like this can of Coke objects to me biting it. And so I'm sitting there and I'm trying to bite it and it's running away and I'm going, that's kind of a non-ideal condition, right? Or if I go and I bite the can and it starts moving the other way, right? Can you imagine trying to bite like they do this as like a party game. Where you've got like an apple that you have either in water, bobbing for apples, or you have the apple on a string and you're trying to bite the apple, right? And when the apple is moving, you're not going to leave the same kinds of bite marks, especially if it wasn't like an apple. It is, a person, right? So that's what they're talking about non-ideal conditions. You're talking about somebody who because the average person, unless it's a kink thing, and I don't think there's any allegations that it's a kink thing in this case, that, unless it's a kink thing, people don't generally want to be bitten, right? They're usually people are like, I would prefer not, right? And, especially like a dog, you don't want to bite it, you don't want to be bitten by a dog. And so the, what is it? You're sitting there going, okay, I don't want to be bitten. And so people do things like if a dog is biting you, you might pull your arm away sharply, or you might force your arm in towards the dog to, to try to gain control over the dog, right? You might do all of these things and try to sort of, try to, whatever is you're trying to sort of fight this bitiness, right? You don't want that to happen, right? So they note that they have little published data and it's unclear if forensic odontologists can identify the origin of these marks under these conditions, right? And that's the thing is they go and they take a mold of the teeth and then they press that mold into a medium and they say, okay, here's the print it makes. But the thing is that print is not running away. It's not straining or anything like that. When I see somebody mentioning Bad Dragon, BDSM, and now biting kink, this has been a wild week for Runkle. It has. As an aside, one of the people who's been a long-time follower and supporter of the channel tells me that they know the people at Bad Dragon. So I had a thought, and I don't think that the people at Bad Dragon would cooperate with this thought. But I had a thought that a toy sort of designed for could be named after like the could be named after like the Alberts. The very talented a-hole could end up inspiring something like that. They could call it the McAlbert. It's and we're at the goal. Okay, I owe you guys showing you some paintings. I will get to a good stop point, and then I will go get the paintings there. All right. I don't think they would put up with it. So, Dr. Crosby fails to articulate any concern over the potential error rate or other aspects of unreliability of his measurements due to these non-ideal conditions. Dr. Russell importantly noted that when a human is attacked by a dog, it's not a static situation. You don't just sit there and let the dog bite you, right? So it's not static. Dr. Russell's report, etc. In this situation, the adult's arm moves as he attempts to get away, and his arm would be bending and moving up and down. You're going to move like, one of those inflatable wacky arm things, right? Additionally, if an adult was wearing clothing, as the decedent was, these measurements likely would be altered even further. This movement changes the nature of the infliction of the wound. Dr. Crosby fails to account for this dynamic environment, an adult moving to get away from an attacking dog, which would affect whether there was a complete bite mark and the measurements. You know what I suspect Judge Canone is going to say about this part? I think Judge Canone is going to say this is not a methodology problem. This is a weakness in his opinion problem, and this is stuff you go into on cross. I think she's going to say this is a cross-examination problem, not an admissibility problem, but I could be wrong. So this also renders Dr. Crosby's entire methodology inaccurate and unreliable. Even under the most ideal conditions where there's a complete and clear bite mark analysis is still not sufficiently reliable, citing to Stark versus City of Waukegan, observing the little amount of scientifically valid data that supports the accuracy of bite mark comparisons. In 2011, a peer-reviewed article noted that because skin easily distorts, it is a poor medium for bite marks. People don't leave good bite marks on other people, right? And they cite to various things. Dr. Russell also notes the human skin's elasticity, what I showed you guys before, which slides over the muscle and bone, right? You got your skin, and the skin moves freely around the stuff, right? Okay. Making it difficult to discern the accuracy of a bite mark. Dr. Crosby fails to discuss this serious concern. Furthermore, the NAS report also establishes that the ability to analyze and interpret the scope or extent of distortion of bite mark patterns on human skin has not been demonstrated. In addition to the absence of a demonstration in his report of general acceptance in the scientific community of the use of forensic odontology and bite mark analysis, Dr. Crosby's report suffers from still other defects. There's still more. They're like, but wait, we have more defects. In 2016, the American Board of Forensic Odontology published a bite mark methodology standards and guidelines report. In it, they discuss various methods to document bite site evidence, including taking saliva swabs of the bite site, impressions of the surface of the bite mark, and tissue samples. While Dr. Crosby cannot access any of these samples due to the DNA failures of the Commonwealth, they're just getting that little chance to get the knife in there. It underscores the inaccuracy of his methodology, i.e., there are techniques that people are supposed to use for this, and they don't, right? And Christy Alman says, thoughts on footnote 2 transcript missing parts. I'm not sure what you're referring to. So I may have missed that. Nowhere in Dr. Crosby's report does he account for the absence of tissue or DNA samples from the wound of the decedent. And nowhere in the bite mark methodology standards and guidelines does it advise using a surrogate, such as a hospital bracelet of unknown origins, to attempt to accurately measure the injuries and wounds on the decedent. So what I'm sure is happening here is he's trying to measure the distance. He's trying to say, ultimately, because he doesn't. So this expert does not get to look at John O'Keefe's body, right? Because John O'Keefe's body is at this point gone, right? So what he's trying to do is he's trying to say that you can't match the, Chloe's bitey bits, the teeth, to the injuries on John O'Keefe's body. And so in order to do that, he has to have measurements for the injuries on John O'Keefe's body. And so it appears that what he's tried to do here is he's tried to say, well, because there's no actual ruler here to give me a firm idea of scale, I'm going to use John O'Keefe's hospital bracelet as a measurement device. That will tell me how much, like how far away those those tooth marks are. Yeah, that is interesting. Yeah. So this methodology of trying to transfer the measurements and apply them to a human wound is undocumented in his report. Also, in the Dr. Russell affidavit, Dr. Russell highlights the lack of support in the Dr. Crosby report for his methodology of using a hospital band instead of an ABFO ruler in assessing the wound on a human. Why doesn't he use the ruler? Because they didn't put a ruler in the picture. Furthermore, the dog Chloe, examined in Dr. Crosby's report, would have bit the decedent on January 29th, 2022. Inexplicably, the Commonwealth waited almost 3 years to analyze and measure the dog's teeth in January of 2025. Dr. Crosby fails to address properly the scientific concern that Chloe, having aged almost 3 years, could very well have experienced changes to her teeth, jaw, shape of her bite, and other aspects of her dentition. I don't know if Chloe was still growing at that point. I don't know if dogs grow during the course of their life, right? But yeah. And Megan Fox says, let's talk about how interesting it is to store blood evidence in solo cups. This part, we don't get to the blood evidence in solo cups, but the whole thing is crazy. Relatedly, it is apparent that the Commonwealth retained Dr. Crosby in early 2024, but waited December of 2024, so waited until to apparently take bite impressions from a dog they claim is Chloe. This apparent strategic weighting boomerangs on the Commonwealth and adds to the unreliability of Dr. Crosby's methodology. This whole thing about like Chloe suddenly reappearing is so weird, right? How do we even know it's Chloe? Like, do we believe the Alberts? Because I don't find them super credible. So, as discussed, Dr. Crosby's methodology and application of methodology in trying to exclude a specific dog, Chloe, or any large dog from being the medical cause of a wound to a person is unreliable. So, the NAS report revealed that it has not been scientifically established that one's dentition will transfer a unique pattern to human skin, or that the pattern would be maintained on the skin. In 2016, in a pretrial hearing in a Minnesota district court, Judge Corey Wawasuk, I hope that's Wawasuk. Okay. If I'm mispronouncing it, there's no way to mispronounce that isn't offensive. So I hope I got that right. Ruled that testimony stating that a particular person made the bite mark would not be allowed. So even the Commonwealth itself appears to have looked with disfavor upon the methodology of Dr. Crosby. They're getting to you guys were making this argument, right? So on June 21st, during the testimony of Dr. Russell, Attorney Lawley asked Dr. Russell if she was familiar with the 2009 NAS report, though he incorrectly referred to it as the NAS report from 2008. Attorney Lawley himself referred to the forensic odontology section, the examination of bite marks, as not a reliable science. And the thing is, remember, there's two things. On one hand, Lawley and Brennan are indistinguishable legally. Lawley and Brennan are basically the same person, and that person is the Commonwealth. That is how that works. However, they also have the problem here that it's a separate trial. They're not necessarily bound by their arguments, but this is kind of embarrassing for Lawley. Attorney Lawley questioned Dr. Russell on the practice of matching the mold of a bite mark to a human wound and noted that the unreliability of the method has led to questioning its validity or its value in scientific objectivity. And now they're trying to use it. It's like, you guys were arguing this is bad evidence. Now you're trying to rely on this. Additionally, the Commonwealth must not be allowed to state that support for Dr. Crosby's purported methodology is buried somewhere listed in 6 pages of random references and materials. There, Dr. Crosby disingenuously lists these as reference and materials consulted that may affect my opinions in this case. So basically, he's burying them in citations. This attempt to camouflage whether he actually used any reference or material he lists, and for which proposition on his long list by the permissive use of may, is improper. I.e., you're supposed to cite to your specific things, right? If you use this thing to support this thing, then they have to be connected. You can't just be like, here's all the books I read. The very purpose of an expert needing to prepare such a list is so that the opposing party can know what sources the witness has considered and is relying on for the propositions in the reported issue. The fact that his entire report is bereft of one footnote further exacerbates this fundamental and scientific failure of his report and his methodology. So they're saying this guy is a clown. This malbehavior of Dr. Crosby of listing pages and pages of seemingly endless materials without regard to whether they support any of the propositions in his report not only deprives the court of properly performing its gatekeeper function, but also imposes an undue burden on the defense. I.e., you're just burying us in paperwork. That is, the defense would be required to read all of the listed materials just to try to ferret out which one may be applicable. Clearly, Dr. Crosby should have footnotes had apt references in the text of his report. He should not be allowed to do a data dump of references and obscure the inquiry for all. This is yet another reason why the Commonwealth fails to meet its burden of proffering a methodology, fails to proffer a methodology that is generally accepted in the relevant medical community, and otherwise fails to proffer a methodology that is reliable. Now we're going to get to an in the alternative, and when we're at the in the alternative, I'm going to go get the painting. So, I will take myself off screen. We're going to listen to Feeding the Ducks. I'll be right back. Just 1 second. Okay, I had a moment of terror there because I went and the things had been in Mrs. Runkle's suitcase. They were the only thing that that she hadn't yet unpacked. And so I knew where they were. They were in Mrs. Runkle's suitcase. And then I went down to Mrs. Runkle's suitcase and it was empty because she unpacked the one thing she hadn't unpacked yet. And I was like, oh crap. So I had to run around the house and I think I found them. I think I have tracked them down. And so let me show you some doggo paintings. So the first one we've got here is a painting of Potter. No, it's not that side. It's this side. That is Potter. And it's so cute. It's got his great big nose. So yeah, these are amazing and they're going up on the wall. We're going to have to get them properly like framed and all of that, but they are totally going to be, they're totally going to be shown off. And we've got another one of Potter. Somebody sent us a pineapple toy and Potter, we got a picture of Potter with that. So that has been captured. So there's another Potter with his pineapple toy there. And so sweet. And we got one more. And this is Celestial Heather. She does amazing work. One more. Let me just pull this out without I'm trying to pull it out without risking any damage or anything like that. Here we go. Zora. It's a big in-your-face Zora. This is so good. It is so amazing because she's such a sweetheart and it just captures her in her just like happy like love phase. So you can those things really capture just like the vitality and the life of the dogs. So yeah. People are saying, Celestial Heather, do you have a link that because there's lots of people going, how do I commission you? Do you have a link? Do you have something where we can pin it and say, here's where you go? Because People are asking, will they go on the wall behind me? I don't know if I've got room on the wall behind me that you guys could see it. I will have to, I'll have to figure that out. So yeah. Can I share a link? I don't know if I have a link. But if Celestial Heather does have a link or has a place, we'll try to get that set up there. What is it? All right. Let's just see. Yeah, Celestial Heather. We'll have to figure all that out. Lee says Runkle accepts fan art. Kind of. If people want to send me stuff, yeah, that is. Have I regained Zora's favor after withholding her preferred amount of food? So Zora is a. I found her on TikTok already. Okay, Zora is. Zora managed to weasel out of us yesterday. She weaseled a second dinner out of us because Mrs. Runkle came home and fed the dogs, and then she left to go to some other thing. And then Zora was like sitting by the dogs and she was whining and she was like, or by her bowl, and she was like, I am so starving. And so I was like, well, she can't possibly have eaten because she's so starving here. She's so, she's so desperate for food that she's got to be like, it's got to be that she hasn't eaten. And so then when Mrs. Runkle came home, I was like, you didn't feed the dog? She's like, yes, I did. And I was like, so, she totally scammed us. And yeah. So I also owe you guys a flamethrower story, or at least my plans for a flamethrower. Now, the problem that I'm having is that the company that makes the flamethrower that I want to get is extremely expensive. And they're even more expensive based on the, what do you call it? The distinction that they have between what is it? The Canadian dollar and the US dollar, because the Canadian dollar has gotten really, the US dollar is real strong. The Canadian dollar is not so strong. So I will just, bring up, let's see. Here is the flamethrower I'm looking for. It is $3,500 for that flamethrower. But I already have a video planned, and the video would be talking about the video is going to be talking about the what do you call it? The legalities of the flamethrower in Canada, because people are like, hey, how much is can I buy a flamethrower in Canada? And the answer is complicated. So what I want to do is I want to get this flamethrower and I want to do a video on that. And the video, I've already got it kind of planned out, because basically so I bought as you guys know, I bought some land, right? And so this land that I bought out in the middle of nowhere is a, what is it? Morgan says, isn't it possible to rent one? Not that I know of. No. But this land has some burn piles that need to be burned, right? I got to burn these burn piles and get rid of them because the previous owner stacked up the burn piles, but they didn't get around to burning them. And so what I'm planning to do, this is the video I see in my head. This is my planning it out in my head, is that I will go down and I'll just be sitting there going like, I'm going to walk up to this giant burn pile. I'm going to pull out a lighter and I'm going to hold the lighter up to the burn pile in the cold. And it's going to be like, this is not effective. And it'll be like, and then it, cuts to me going, and then, and then the next thing is I've got this boom box, this old boom box that I've had since forever. And it'll be me thunking the boombox into the snow, hitting play, and then like, you know, sort of metal-ish music comes out. And then I will, you know, and then it'll be me throwing on the flamethrower and then just, you know, just torching this thing up. And yeah, so that'll be sort of the beginning of the video if I get this down. The, you know, boombox, play, foosh. I also, because there will be the question of whether or not it's a firearm, I'm going to have to do my typical pig's eye test. So there's going to be a little skull with pig's eyes, and then I'm going to flamethrower it just to be like, all right, we'll do that. So I want to make this happen. The company Throw Flame, they've got a thing of like reach out to them, and I have tried to reach out to them and they haven't reached out back yet, but I'm hoping that they will. So yeah, the other thing that the same company makes, and I would totally like, they make an extremely bad dog. And I will show you that right away here, just so that you can see that. This is a $10,000 robot dog that has a flamethrower mounted on it. And so you've got a robot dog with a laser sight, apparently, that shoots fire. I'm not sure why I need this, but I totally need like a flamethrowering robot dog. But I don't have $10,000. So yeah. I don't. Yeah. So they also have a thing where you can attach a flamethrower to a drone. Yeah. Okay. So now that we've covered our interludes, back to the thing there. So in the alternative, should the court not grant the defense's motion on the papers to exclude the testimony of Dr. Crosby based on his lack of qualifications and his unreliable methodology, the defense requests an evidentiary hearing to establish the failure of the Commonwealth to meet its Daubert-Lanigan burden regarding the testimony of Dr. Crosby. So they're basically saying you should throw him out based on his filings, but if they don't throw him out based on the filings, then you should totally, then you should have a hearing. And somebody says the range is 30 feet. The range is 30 feet of the flames. I don't know what the range is on the actual dog from the thing that controls the dog, but the range on the flames is 30 feet. So yeah. All right. So conclusion, Dr. Crosby is not a medical doctor. On this basis alone, his testimony must be excluded as he fails to meet the first and crucial prong of the Daubert-Lanigan standard for the reason expressed in Your Honor's June 18th ruling. Your Honor already ruled this, already decided this. Yeah. In addition, Dr. Crosby's proffered methodology is not generally accepted in the relevant medical community and is otherwise unreliable. For these reasons, and for the other reasons stated above, Ms. Reed respectfully moves this court to exclude the testimony of Dr. Crosby concerning the medical cause of injuries to the right arm of the decedent on the papers and without need for an evidentiary hearing. In the alternative, if you're not going to exclude it without an evidentiary hearing, give us an evidentiary hearing on the, then we request an evidentiary hearing to establish the failure of the Commonwealth to meet its Daubert-Lanigan burden regarding the testimony of Dr. Crosby. So, yeah. Signed, Robert J. Alessi, Esquire. And, Runkle, how do you evaluate the answer on the pig's eye test with the new toy? It would be basically, are the pig eyes okay? And so the plan would be that I set the skull with the pig eyeballs in it, and then I set it down and I flamethrower it. And then I would probably have that plastic skull and the eyeballs, I'm imagining, would be like on fire and destroyed. And it would be like, yeah, I think that could cause serious bodily injury or death. I might do it with a what is it? I might also do it with the Paul Harrell test. The Paul Harrell test being I get a big slab of meat and I just flamethrower it and be like, so how's that? I don't know if I'm crazy enough to do the Paul Harrell test and then try eating the meat afterwards because it's going to get sprayed with like gasoline and but I think I could have a lot of fun with this video, and I've been trying to get Throwflame to answer me because I really want to borrow one for the purpose of doing the video, and I will send it back because I get that they probably don't want to send me a $3,500 thing. But yeah. Yeah. In other news, I will also soon have a set of night vision goggles. That's coming. Well, not night vision goggles. I'm going to have a night vision monocular. So it's just one eyeball. And what is it? I'm just, yeah. Flamethrowers are not complicated. Build one. Here's the problem with building one is that I need it to be built by somebody who knows what they're doing because I'm going to be wearing a tank full of pressurized gases and fuel on my back, and I need it to not like blow up on me. So yeah. Somebody says maybe you can sign it so that when you send it back, it's not used, it's endorsed. If they were down for it, I would totally take it and run it through. I've got an airbrush, so I'd totally take it and like airbrush the hell out of it, and then they could sell that as the Runkle design. That would be cool. That would be pretty awesome because then I could be like, hey, and then I could have some B-roll of me airbrushing it and, making it into a unique Runkle design so that then I could go through and be like, yeah. I need those guys to email me back, though. So, yeah, I'm trying to chirp them on Twitter. I'm trying to find out where they live. So, yeah, try to figure out how to do this. All right. So, that is the motion. And now we can look at the affidavit of Dr. Marie Russell. So, in support of the defendant's motion to exclude the testimony. So, this is Dr. Marie Russell basically getting to say, your expert sucks. And she's going to have fun with that. So, I, Marie Russell, MD, she's putting the MD in there. What is it? Under oath, do depose and state as follows. 1, the following facts, analyses, and other information are based on my own personal knowledge, and I could testify competently about them if called upon as an expert witness to do so. I declare that the following is true and correct to the best of my knowledge, and that I have no personal interest in the outcome of this case. What is it? And campsite. I don't know about that case. Shoot me a message about that one, and I could possibly cover it. So I am a licensed medical doctor, and I'm currently engaged in the practice of medicine. That's not really hard shade, but it's a little bit of shade because she's like, yeah, your guy is not an MD. I am an MD, and I am totally a thing. Campsite, send me the link. Send me the details. So, yeah. I have approximately 30 years experience as an emergency medicine physician and as a forensic pathologist. Further information about my education, training, experience, and knowledge is set forth in my CV, which is attached to this affidavit as Exhibit A, and in a report dated December 9th, 2024, Dr. Russell report, which was previously submitted to the court in this case, and which is attached to this affidavit as Exhibit B. Now, when you walk into lawyers' offices, they often will have like many, many leather-bound volumes of stuff. And the thing is that you could have an entire shelf of leather-bound volumes just for her CV. So, yeah. I also testified extensively at a Dauber-Lanigan hearing before the court in this case on December 12, 2024 and January 7th, 2025. After this testimony, the court rendered a decision in which I was qualified as an expert on the subject matter of the medical cause of wounds inflicted to the right arm of the decedent, Mr. John O'Keefe. I have read and evaluated the self-styled preliminary report. Self-styled preliminary report. Maybe I don't need a flamethrower. Maybe I could just borrow Dr. Russell for a bit and she could be the flamethrower. Because, yeah. Of Dr. James W. Crosby, MS PhD of Canine Aggression Consulting, LLC. Dr. Crosby is not qualified to render the opinions and draw the conclusions stated in his report. Also, the methodology he uses to reach the opinions and conclusions in his report is incorrect, flawed, and otherwise unreliable. These two overall deficiencies relate to each other, meaning his lack of qualifications likely contribute to his flawed methodology and conclusions. It's like, it's not his fault his methodology is dog shit. That's because he's not qualified. He's using shitty methodology because he's unqualified. The subject matter of the opinions in his report is the cause of the wounds to the right arm of the decedent. The opinions in this regard are variously stated on pages whatever of his report. For example, on page 1382, he states, I was asked to examine the evidence in this case, including images, reports, and the involved dog itself, and determine, if possible, the potential source and nature of the defects documented on the right arm of the decedent John O'Keefe. Sir, shouldn't you say the alleged involved dog as opposed to the involved dog? That's language that I would have been like, yeah, okay. I was particularly asked if I could determine, to a degree of scientific certainty, whether those defects were consistent with a dog bite or other animal bite. I have never heard of one stating wounds to a human as defects, nor have I experienced a non-medical doctor acting on his or her own to determine the medical cause of an injury to a person, antemortem or postmortem, or why they're alive or after they're alive. So, lack of qualifications of Dr. Crosby. Dr. Crosby is not a medical doctor, nor is he a forensic odontologist or a veterinarian. He does not appear to be licensed in any medical or scientific field, or to possess any other professional license either. He does not appear to have taken any nationwide examination for his stated specializations. So it's like, what are these? Are these certificates from some sort of unit? Like, what are these? So I am unfamiliar with the 2 degrees he possesses in veterinary medical science. I have not heard of either in my 30 plus years of practicing medicine, including forensic pathology. It's like, where do these degrees come from? What are they from? What the? Jim Crosby was fired from some animal shelter for eating a pet pig? I don't know if that's correct, but wow, that's a hell of an allegation. Okay. He does, if that's, so I'm seeing an allegation that he was fired. I'm trying to Google this now. James Crosby eats pig. Not like, did this make the news somewhere? No, I am just trying to see what's going on there. I see a lot of stuff about Cromwell. I don't want Cromwell. I want Crosby. So I don't know what's, I'm not seeing it. I don't know where the, I don't know where this is coming from. So I don't know the details on this, but apparently Turtle Boy was saying he ate a pig. Somebody's pet pig. What's going on? He resigned because one of his employees took home an aggressive pig and ate it. Okay, if it's an employee, wow. The thing is, if he's connected to that, that's gonna be used in cross. They will totally use that in cross, if that is a thing. He did not reprimand a subordinate for doing so. Okay. It was someone he supervised. Okay, if it's someone he supervised, I don't think that's much of a thing. But they'll probably try to use it in cross to be like, hey, this guy is some sort of, some sort of animal, some sort of crazy person. Like, you don't want to believe this guy. He's a weirdo. Yeah. He does not specify in his report any requisite education or training he possesses in the forensic examination of humans, including in the highly specialized medical topics of wound identification and wound direction in humans. He does not state in his report any training in the highly specialized and scrutinized area of forensic photography. He does not state in his report that he worked with a forensic pathologist or a medical examiner for any matter addressed in his report. He states in his report that particularly at question is whether the wounds on the right arm of the decedent are caused by a dog named Chloe or any other potential large dog. Potter is innocent, by the way. Potter has an alibi. Leave Potter alone. But then he strays from that charge and claims that certain wounds on the right arm of the decedent are consistent with an engagement of some sharp or semi-sharp object. What's a semi-sharp object? Other than Lally. Lally is semi-sharp. He does not state in his report any qualification that would allow him to make such a claim. In my experience, only certain medical doctors are qualified to make such a claim. I am one such medical doctor. Zing. Lack of reliable methodology of Dr. Crosby. There are numerous errors and other flaws in the methodology and application of the methodology described and utilized by Dr. Crosby in his report, which individually and collectively render his report medically and scientifically unsound and otherwise unreliable. This affidavit is not intended to address all of these flaws. It's like, there's so many flaws. It's like, let me explain. Oh, there is no time. Let me sum up. But the ones I do discuss each render his report, and especially the opinions and conclusion in it, unsound and otherwise unreliable. From an overall structural perspective, his report is defective scientifically and medically. He does not footnote any source of authority in the text of his report. At the end of his report, he merely lists numerous references and materials that he states may affect his opinions in this case. That's a very sloppy way to write a report, by the way. He also describes his report as a preliminary response to your request. Neither of these approaches meet medical or scientific norms for the use he apparently intends for his report. Likewise, it's like we use footnotes. Footnotes are how we do this. Somebody says, was that a Princess Bride reference? Of course it was a Princess Bride reference. Likewise, I like Princess Bride a lot. Mrs. Runkle loves Princess Bride. Mrs. Runkle watches Princess Bride a lot, and I'm pretty sure Mrs. Runkle can still quote. Put it this way: at one point when we were on a road trip, Mrs. Runkle and I, Mrs. Runkle had had watched or was able to recite Princess Bride verbatim while we were on this trip. She was just like acting out the parts. It was really entertaining. So yeah. Likewise, he does not provide in the text of his reports any citation to any literature source which would show that his methodology or his application of the methodology under the circumstance of this case are in accordance with general acceptance in the medical or any scientific community. Wound analysis methodology of Dr. Crosby. The subject of wound analysis, including wound directionality in humans, is a highly specialized area of the practice of medicine. Many physicians lack sufficient knowledge, training, experience, and skills to engage in this area, which is the subject of substantial training and many medical textbooks and peer-reviewed articles. She's like, this is not something you just decide you're going to do sometime like randomly, right? This is not just something you just decide you can start doing. You need a ton of analysis. You need a ton of experience and training, and you don't have it. You know who has it? I has it, she's saying. Like Dr. Russell is going, that's me. That's me. I possess the requisite education, knowledge, training, experience, and skills in this area. I'm an expert. You are not an expert. No. The methodology and application of methodology by Dr. Crosby concerning the wound analysis of the right arm of the decedent are incorrect. First, she's like, I know how to do this. And let me tell you all the things that that are wrong. First, he evaluates the decedent and his wounds as if they were the subject of a static environment, as opposed... Oh, we got doggo opinions going on in the background. As opposed to the proper dynamic environment that existed when the decedent was being attacked by a large dog. He wrongly evaluates a dynamic human body like it was a hard plastic and static mannequin. For instance, he does not account for the movement of the various body parts of the decedent during the attack, such as the substantial flexing of his right arm or the movement of his right shoulder to protect himself that would decrease the angle of the elbow and move the wounds closer together. She's saying basically he's a human. He's not a mannequin. And humans move. Humans react. Humans have... And the thing is it's kind of obvious that humans react. One of the really common things that will come up in forensics is defensive injuries, right? And defensive injuries, you get all sorts of, let's say you got somebody who's got a knife. They're coming at you with a knife, right? And so you get various kinds of defensive injuries. You get defensive injuries that are like stabs into the hand. And that's because somebody's trying to stab you and you reach up to block it and you get stuck in the hand, right? That happens. You also get like slashes and cuts to the arm because people will block as they're getting slashed and they'll get these slash marks. And the thing is that those kinds of defensive injuries that are very, very common in murder cases, in criminal cases, these things happen because humans move, right? These things happen because humans react. And she's saying his methodology is bad because people react, people move, people, all the things, right? So that is why his methodology is bad. And I mean, when you think about it like that, when you think about the fact that every single case involving like stab wounds, like if somebody doesn't have defensive injuries, you really expect one of a couple of things, right? If there's no defensive injuries, you expect that either somebody was attacked by surprise, like maybe you get stabbed in the neck before you realize that, and then you're just like, I'm bleeding out the neck, right? Like, I'm going to die. Or somebody stabs you in the back and you didn't see it coming, or you were asleep, or somebody you trusted approached you and then stuck you, right? All of these things, but you're going to, like, if there are no defensive injuries, you're going to want some sort of explanation. Now, I saw somebody saying, how many weapons are in my office? And I don't know because my office is a mess, but I at least have this knife. And I also have the ouchie stick. The ouchie stick is also here. And I also have I also have this. Just saying. There's also at least a few things that I cannot show you on a stream because YouTube does not like me handling certain things on a live stream. So let's just say that there are, and in case I have an accident with the with that, I've also got this. I've got the tourniquet on standby. So we have the things to make holes. We have the things to deal with holes. So yeah. All right. So the failure of Dr. Crosby to account for these movements renders wrong and unusable all the wound measurements in his report. Dr. Crosby wrongly applied his canine dentition measurements to a theoretical static right arm, which angle of the elbow crease never moves during a dog attack, according to Dr. Crosby's methodology, but remains fixed as it exists in the photographs he has in his report. He also does not account for the elasticity and compressibility of human skin, which is also not static. So basically, she's saying she treats him like he was already frozen to death. Now, Edward Scott says, how are there gun channels on YouTube, but YouTube is nutty about guns on stream? YouTube has a rule about guns in a live stream. And the reason why is because if you're uploading like a range video or something where you filmed this at the range, then there's no chance of accident. But they did have a couple of instances before they set this rule where people like had incidents where they were like handling a gun and the gun went off at their desk. And so YouTube was like, if we don't have a rule banning guns from being handled on a live stream, eventually somebody's going to accidentally shoot themselves on a live stream. And yeah. So, yeah. Is consenting to a peace bond an admission of guilt or responsibility? It is an admission of certain things that you should talk to your lawyer about. So, yeah. All right. Likewise, there are structures immediately below the skin, such as bone and muscle, that would be and look different during the dog attack. The static methodology approach by Dr. Crosby is medically unsupportable and incorrect and renders his measurements unreliable. Second, he wrongly bases his analysis on individual wounds or individual sets of wounds as opposed to the overall pattern of wounds. Third, the directional arrows he inserts into the picture of the decedent on page 1394 of his report are going in the exact opposite direction of how the wounds were actually inflicted. Because of this error in directionality of the wounds, his measurements and conclusions about the distance between the wounds are incorrect. It is therefore his analysis that suffers from a conflict in orientation. This is another flaw in his methodology. This point is one that they're never going to win on, right? They're never going to win on the conflict of in orientation because of the issue that that's going to be a disagreement, right? That's going to be a disagreement on that one. So Hayden says, when you get a chance, can you teach uncivil law the difference between dog bites on dogs versus humans? He seems to think they're all the same between dogs, humans, mannequins, fruit, etc. I don't police other creators. Other creators can have their own opinions, and he might be right. So, fourth, Dr. Crosby's arch analysis methodology is incorrect. He claims that the arch is backwards if the wounds were inflicted by a dog. The direction of the arrows he shows is wrong relative to the arch he proffers. So he says the arch is backwards. He says the arm is backward, like that the direction is backwards. And it might be, in fact, that the direction is backwards, which makes the arch correct. Right? Again, these are failures of Dr. Crosby to account for the dynamic environment during a dog attack. And these failures render his measurements incorrect and unreliable. Fifth, Dr. Crosby does not account for the partial or incomplete bite scenario that is present in the wounds of the decedent. Here's the thing, right? When you bite, like when a dog bites you, it may not get a perfect bite every time, right? So, you're thinking like, okay, you got an arm there and you're like, right? You get the perfect bite. But maybe the dog only gets like it's biting at an angle and it goes, and only one tooth goes in, right? That's a partial bite. And so all of those are different potential, scenarios there. And yeah, LA says, I remember one kid wanted to be viral and his 19-year-old pregnant girlfriend shoot him while he held a hardcover book, maybe the Bible. He was supposed to survive. He didn't and died on stream. Yeah, they used a 50 AE. They used a Desert Eagle for that. It was stupid. The other thing that happened in Canada, there was a guy who wanted to test like AliExpress or like, Temu.com body armor. They bought some body armor online, and it was cheap, crappy body armor, or maybe it was a plate carrier. And they put it on and had his buddy shoot him, and it went right through the body armor, and buddy died. And then the guy who shot him ends up going to jail for a good long time. So, yeah. All right. He wrongly assumes both jaws of the dog would be making compression as opposed to glancing bites against the skin and less than all teeth impacting the right arm of the decedent, which is really common. Nor does he account for the effect of the hoodie sweatshirt the decedent was wearing in making and discussing his measurements, conclusions, and opinions. These are more defects in his methodology. So he's wearing a sweatshirt, right? So let's imagine you got the sweatshirt, which is a much thicker fabric than my shirt, right? My shirt is a fairly thin fabric. But let's say you got the sweatshirt and it folds over, right? And it, so now you've got like 4 layers of sweatshirt, right? You see how there's, you get 2 layers with just the pinch, and then you fold that over and you end up with 4 layers of sweatshirt, right? Let's say you bite, right? I'm Chloe. I bite the arm. The lower teeth might be having to go through 4 layers of sweatshirt in order to get the skin, and they might not be sufficiently long or whatever, to do that. Whereas on the top, it might just be 1 layer because it's pulled tight. And so then you're going to end up with a situation of bites on one side and not on the other. And that's perfectly consistent with the scenario we're looking at, right? So, yeah. So, photography methodology of Dr. Crosby. Forensic photography requires proper qualifications and training. The use and application of forensic photography methodology is highly scrutinized, and for good reasons. So there is no discussion in the report about who took the photographs or how they were taken. It is obvious that at least one of the photographs is distorted and not a depiction of reality. This is a failure of proper forensic photography methodology. Let me give you an example of bad forensic photography methodology. Here I am holding a glass. This glass of scotch appears to be, and I really need to cut my nails. Okay. This glass of scotch appears to be as big as my head. Right? And my hand is giant. That's got to be like a little ocean of scotch in this glass, right? No, that's a distortion because I'm holding my hand way up there, right? When I bring the glass back down to my face, you can see it's a little wee tiny glass, and it's got a little wee tiny bit of scotch in it. I had just a little tiny wee taste, and it's half gone. Okay, because I don't drink a whole lot of scotch on stream. I will taste scotch on stream. I don't drink to get smashed. That's not a good thing. So, the thing is you've got to be very, very careful when you're doing forensic photography that you don't run into like accidental forced perspective, that you don't run into all of these potential circumstances, right? And so, you got to be careful. That's what she's saying, is that if they don't do the photography right, then that's an issue. Runkle doesn't lick the scotch bottle, therefore he's drinking responsibly. Everyone can see and know that. Let's just say there's certain things you don't do with the scotch bottle. So, moving on. Also, there's no documentation of general acceptance in the medical community of the use of the hospital band Dr. Crosby applied as a substitute for the requisite American Board of Forensic Odontology two-dimensional ruler, which neither the photographer at the hospital nor the medical examiner for the Commonwealth used, as they should have, in photographing the wounds on the right arm of the decedent. I.e., they didn't put a ruler on it, so we can't actually tell the distances. And instead, he's trying to infer distances from this hospital band, right? He's like, well, the hospital band's got to be an inch wide, so we're gonna like that's like no. No. Dr. Crosby attempts to make much about the supposed absence of dog DNA on the clothing of the decedent and how he believes this supports the absence of a dog bite. Okay. This application of forensic methodology by him is incorrect and unreliable. The Commonwealth did not swab the wounds of the right arm of the decedent for dog or any other DNA. They swabbed the clothing, but not the wounds. Also, there's no documentation of proper collection, handling, or chain of custody for the clothing of the decedent or the swabs used on the clothing. Your DNA testing is so garbage. The DNA testing protocol for dog DNA employed by the Commonwealth and relied upon by Dr. Crosby in his report is based on a flawed foundation. As a result, the supposed absence of DNA claimed by Dr. Crosby in his report does not reliably support a conclusion that dog DNA was not on any wound of the decedent or on his clothing. So that is Dr. Marie Russell. She is coming in hot. She's coming in spicy. And that's not all, because we also have a motion, and this motion, we got some spice on this one. And I got some thoughts on the next motion. We are way behind on super chats. Chat, should I get through some super chats? I feel like I should, because we got one more document we're going to cover today. And so let's cover the super chats, and then we will go to the remaining document, which is when I promise Sandra Birchmore comes into this. We have not yet seen Sandra Birchmore in this proceeding, and we are going to get there. So Greg, 4 to exclude sounds like that really dumb dude who says things a certain way because he thinks it sounds smart. I think that what it probably was is they had a precedent and they just improperly corrected it. Chop Trial says, boom is not legal life advice. For a combined $20 of super chats, I feel like you could do better. Okay, fair. Life advice. I can give a few different pieces of life advice. Let's see. Life advice number 1. You do not really know somebody, and you don't really know if a friend is a friend until you've had an argument or a fight with them. Until you had an argument with a friend, I do not consider them a proper full friend. And that includes in relationships. Like, if you're looking for like a partner out there, consider, like, you're going to have a disagreement at some point. Consider how they handle disagreement and adversity, because at some point in your relationship, you will have some sort of disagreement or adversity, and there's going to be stress. And this is a point, but don't start an argument just to check. Fair. Have you had an argument with Rob? Yes. And we just talked it out. It was Rob and I talked out, we had a disagreement. We talked it out. It was all good. So Rob argues like a reasonable person and does not immediately go, I freaking hate you when you disagree with him, and so forth. So yes. And I got to roll. This. Jada Juror says, you call it grift, I call it channel support. Thank you for the Sandra update. Thank you. We're getting to the Sandra update. It'll be in there. It's kind of a weird update, but because it's kind of a backwards connection there, and we'll get to that there. Actual Runkle advice, I remember, don't share blankets. Yes. What is it? I think it's good advice to have separate blankets. Mrs. Runkle and I, we have one bed, but we have separate sets of blankets. And there have been instances where, because my back is bad, I have tossed and turned enough in the night to end up with all of the blankets on the bed beside me. And Mrs. Runkle still has her blankets. So Mrs. Runkle was probably really glad to have separate blankets because otherwise her blankets would have been on the bed too. So, yeah. Celestial Heather says separate bedroom here, 15 years strong, works for us. It works for people as well. So, yep. Linz says, I get the saddies, so super chatting my favorite Canadian lawyer for the dopamine. I'm sorry, Linz, that you've got the sads. I get that. I hope you're feeling. I hope it helped. I hope you're feeling okay. I hope I hope that me sort of waving does something. I hope. L Fliggins says, now I'm curious about the flamethrower. Fair. Daily Dysfunction says, thanks for your coverage as always. Thank you so much. Greg says the canon was not an agreed upon methodology. Brennan, probably. Callista says, for anyone who doesn't know, the prosecution and the defense were both given the same ARCCA report by the feds. The prosecution chose not to interview the crash daddies. It's on them. Yeah, I feel like they want to play this as a game. Nancy Druby says, love your surprise streams. I just was like, there's so many things and I want to talk about them. And I want to talk about them so much. So I was just like, I want to do that. So what is it? My hubs and I started doing that as well. It's been a game changer for our sleep. So thank you for the story. Yeah, separate blankets is like an absolute life hack. And like the amount, Mrs. Runkle was skeptical when I was like, we need to do separate blankets. The internet says separate blankets because I found that piece of advice on the internet. And she was like, isn't that going to be less? And no, now it's like, absolutely. So yeah, it is a good thing there. It actually does help when you have the SADs, you feel invisible. It's so bad. And then someone treats you like a human and it helps. I try to do that. And I try to sort of call out some messages that are not super chats as well. Cause sometimes people have something that's sort of they need to say, or they want to say, and that, they can't super chat. So, yeah. Rainman YYC, tell us a story about what you're doing. I am up to so many things right now. Tough Cookie says, for the goal. Thank you so much. One of the things I'm up to is trying to get all my all of the extra life packages shipped. So I'm working on that still. So Joy W says, to hear flamethrower story. We covered that one, but thank you. That was previously covering that one. Gordon Ramsay says, does Canada really have a catch and release policy? Canada has bail policies that have a healthy regard for the presumption of innocence, because keep in mind, after you are arrested, you haven't been convicted of anything. And so bail is important because a lot of people get arrested and they turn out to be, innocent. They get acquitted. And yeah, so it's not really a catch and release policy, but people characterize it like that. Emily Aaron says, I used that sentence as too many syllables. Apologize at work the other day. So thank you for introducing that into my lexicon. So here was a fun thing.
That said too many syllables. Apologize.
That's the clip that's being referred to. It is from Borderlands. Now, earlier I was in court on video court, right? So I'm there and I was moving my mouse, and right next to my mouse is the machine with all the buttons. And so I moved my mouse and my finger
said too many syllables. Apologize.
did that. And I had a moment of terror because depending on how which audio output I'm piping to the WebEx thing, I was like, did they hear that? And the thing is that the moment of terror was it was okay at the end of it, because it turned out that it was on a different audio channel. So I'm just playing this now. You're not going to hear it. So you don't get to hear that, but I did. So it was configured like that. So the court never actually heard the Mr. Torg quote. But if they did, I would have had to do some explanation as to like, Mr. Runkle, what was that? And it would have been like, well, Your Honor, I do live streaming. And so sometimes I need to play, I need to play sounds. So like, this one.
Oh, they took my freaking kidney.
Yeah. And I don't know if the court would have accepted it. Somebody says, why is it echoey? It's echoey because my sound is misconfigured. I need to figure that out. And the reason why it's echoey is because it's playing once into the audio and it's playing a second time through my own audio. I think I can fix it. Might be able to fix it right now. I'm just trying to see here what I'd have to fix the audio piping. What is it? Because I've got audio piping. I don't know if I can. Maybe let's try it. Here, chat, tell me if this is still echoey.
Oh, they took my freaking kidney.
Is that still echoey? I don't know. Was that echoey still? No, so that fixed it. Okay.
Oh, they took my freaking kidney.
Okay, so maybe I've got that fixed. All right, so that helps. So yeah, I need to get some more things for that one. I need to take this clip and just get the audio so that I can just run it as an audio thing.
Conspiracy.
That one is from Duckman. I gotta get some more audio clips and so forth, but most of the stuff that's still on this, by the way, is stuff that's from for Lawyers and Dragons. So I've got stuff that I was planning to use with Gimlet for his audio sounds. So what is it? I've got okay, that was probably real loud. I was planning on having Gimlet at some point use the da-da-da-da thing for his entry. I've got the I've got this. Bonk. I've got the acid sound. But what I was really planning on doing, I had one that I was planning on doing for Gimlet that I've got this, which is fun. So if you need to use a sound effect to make it happen somewhere else, it's that sounds like something. But I was planning on using this to mess with somebody.
I love you.
I was planning on doing that with in a key moment in a Lawyers and Dragons game, because that would really mess with somebody to hear, right? So yeah. Somebody said, is there going to be more Lawyers and Dragons? I don't know. That's up to mostly Hogue. So, yeah. All right. Defendant Karen Reed's motion to compel discovery. So they want more information from the prosecution. So, yeah. Now comes the defendant, Karen Reed, who respectfully moves this honorable court. I see somebody said that we have a motion for whenever we get now comes the defendant. Now comes the defendant, Karen Reed. Who respectfully moves this honorable court pursuant to the rules to order the Commonwealth to produce the following discovery. That's going to be a thing. The items of discovery set forth herein are relevant and material and must be provided in accordance with Ms. Reed's constitutional rights to effective assistance of counsel and to due process under the law as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 5th, 6th, and 14th Amendments to the United States Constitution. So, all right. Basically, they're saying we get evidence. In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence. Oh, right. I didn't finish Super Chats. Duh. Yeah, I suck. Okay. Cool Spring says, we need the plan. I told you the plan. Sardinism says, would this not create a huge loophole for the government to use in future cases? Refuse discovery to hobble defense sounds like bad precedent to set. The prosecution uses this all the time. They say, we don't have this material. You have to get it somewhere else. Vomit Fountain, for the goal. Thank you. Raven 254, for the doggos. The doggos are good. They will get treats in a bit. Pamela Wissenbach, doggo video. Tough Cookie, thank you for 10 gifted memberships. Much appreciated. Vomit Fountain, is the dog in the video wielding the flamethrower from your upcoming story? Because that would be awesome. Letteros by Bettero, thank you for 1 gifted membership. Much appreciated. Stephen Miller, I hate bonus streams more than you hate super chats. Thank you so much. Laura Christine, thank you for the doggo video. Rainman YYC, puppy. There we go. Phoenix Waller, access to the dog that defense asked for before trial 1. Yep, suddenly this dog exists. Cal Marie says, anything for puppers. I got to make more puppy streams or puppy swoops. Wicked Psych, they tried to discredit Russell during the qualification hearing with identifying bite marks that were moles and freckles. Could that be the reason for using the word defects? It might be, yep. DSN, thank you for the super sticker. Kylie, has Rob filed any motions on Zora's behalf on the diet case yet? No. Pochi, cheers Runkle for liking Duckman. Cult classic. It is a cult classic. Greg says, Bev's going to be in such a pissy mood when she realizes she's stuck ruling for the defense. It's going to ruin her whole day. Shay B, thank you for the YouTube membership. Much appreciated. Against the Tide, y'all, please like this stream. Hi, Replay Crew. Thank you, Against the Tide. Shay B, thank you for the 20 gifted memberships. Very generous. Much appreciated. And Tracy Sires, thank you for the 10 gifted memberships. Shay B says, defense says, heads I win, tails I win. That's exactly where you want to be. Cheryl Ellis says, free Runkle of his need to bill clients. That is the dream. Light Queen, for the goal, YouTube and pro bono. Thanks for all you do. Thank you so much. Satan's representative. That's a hell of a name. First time catching your live. Just wanted to say thank you for all the time you have and will take to educate us on the law. Thank you so much. Candy Marie, thank you so much. Light Queen, the Commonwealth tried to find their own Dr. Russell and failed miserably. They kind of found their own Trooper Paul. Mispronounced name, Grifting. Thank you. Reese's mom says, Big Von was trolling during Lawyer You Know stream earlier. I like to think that Big Von's trolling attempt didn't go the way he wanted, and so he bailed. A. Hedinger, I appreciate your grifting. Thank you so much. Cheryl Moran, oh my God, I love that Runkle. This was about the troll toll. Amara Deshane, the most polite way I've ever seen someone shut down a troll. He did just shut down. That was fun. Morgan says, because Ian doesn't play turn the other cheek with the trolls, point them out, shine a spotlight, laugh, and mock them for the sad sacks that they are. The trolls really kind of illustrate their own problems. So Potion Master Danya, can I have a pet dinosaur, please? If I had the power to give you a pet dinosaur, I would probably have 3 pets right now. Be Zora, Ripley, or Zora, Potter, and Dino. JBF, catching up, Monkey SK. There we go. A mispronounced name, Counter Grifting. Canadian Nico, thank you for the $5 super chat. Much appreciated. Rainman YYC, patron of the arts chat. Thank you so much. Vomit Fountain for the art, the grift, and Celestial Heather. Celestial Heather did some amazing work. It is wonderful. I need to get those framed and put up on the wall. Laura Christine, for the grift of it, thank you. That's probably a project for this weekend, is take them in to get them framed. So Dina Kawaji, thank you so much. Much appreciated. And I will flag a couple of those. I see a couple of things I will cover there. Lindsay says, would Potter or Zora attack someone if you were in danger? I think Potter would. I don't know about Zora. Airy Persiflage, airlines have non-standard landings. They're bad. Yes, a non-standard landing does not sound good. Lola, the good dog. Another dog growled at me on our walk. Lola slowly backed away from me as to say, I'm not with her. Tiny dog security, lol. Tiny dogs are funny because sometimes they will go hard for their owners. So Reese's mom, Vicky, Runkle biting a Coke can was not on my bingo card. I needed something to illustrate the point. Christy Almont, thoughts on footnote 2 transcript missing parts. Yes, Against the Tide brought that up. Apparently the transcript is missing that bit, so they had to transcribe it from the YouTube video. That was interesting. I'm Kelly and I grow it. Ian, do you think this trial might get dismissed? I think the odds are very low, although I think that maybe it should be, but the odds seem to be very low. Recovery Addict, hoping the mail delivered your coins. It did, and I need to turn those around. I think some of those are for other people, so I need to turn those around and get those sent on. So thank you so much, Recovery Addict. Mr. Sharpie, hopefully Commonwealth can't get snakes from chicken eggs. Their way to excluding the dog bites entirely. Also, apologies if my email a few weeks back sounded too much like Hollywood LMAO. I'm not sure which one you're referring to, so yeah. Pamela Wallen, thank you for the YouTube membership. Cherry Mills, thank you for the membership. Jane Sidlauskas, can you find out and sign up for our government auction that is held for military surplus? I don't know, and I don't know if the U.S. would ship me a flamethrower right now, with the U.S. kind of at soft war with Canada right now. So yeah. Linde Kai, are tactical canes legal in Canada? Some are, some are not. It depends on their design. Michigan Farm Boy is at a rare to well done scale. Fair. Fiona W, thank you for the 10 gifted memberships. Much appreciated. Reese's mom says, you should buy the flamethrower on credit, do your thing with it, paint it up, then auction it off to pay it off. That's actually an idea. It's actually an idea. Do I know anybody who would pay more than 3,500 US for a flamethrower that I airbrushed and that was in a video? Maybe. I don't know if I can. I don't know where I can sell a flamethrower, so maybe I'll have to do that and like put it up on like my Shopify store and just be like, so flamethrower. Yeah. Gray Space, Crosby describes his qualifications as certified behavior consultant, canine knowledge assessed, CBCCKA, issued by the organization that he founded and where he serves on the board. Oh shit, he qualified himself? What? That makes no sense. That makes no sense whatsoever. Lola the good dog, Dr. Russell is Crosby's arch nemesis. I love it. Marvin CZ, I love that Dr. Russell's affidavit for the most part covers issues critical for this motion, qualification, and actual methodology, and strays only lightly into difference of opinion. Breenan should take notes. She also has a little bit of snark. Michigan Farm Boy, the canon is what Mythbusters would have done, so it must be the accepted methodology. Fair. Gwynny Bly, bonus live, woohoo. Blanket 3 equals mine, there's ours. Fair. Angie says, Charlie the Unicorn reference. Yay. I love that sequence.
Oh, they took my freaking kidney.
Cool. Fancy RPG says, hi, Runkle, making you a nice dice bag. Thank you. Tam Jules, did you see Bruce Rivers' stream about his son? I didn't. Stupid trolls didn't help his issues at all to the worst degree. That is really the thing that is bad about this. Is that if anything happens during this, like if anything bad happens, people will be there happy to see you fall, right? And so, like I think most of my chat are fairly good folks. And so if, for instance, if my wife was injured or something like that, people would be supportive, but there would be people out there who would be shitty about it, right? The anti Karen Reed people would probably be like diving in to make shitty attacks. So yeah, I mean, what happened to Bruce Rivers and his family is tragic, and anybody who goes after them can go to hell, and probably will. So yeah. So Gordon Ramsay says, Runkle, is there such a thing as a prison industrial complex in Canada? Yes, but not to the same degree. Mrs. Runkle's sneezing, allergy to the Canton BS. I don't know what the sneeze was about. So yeah. Gains the tide or grift off of your pain. Scott Cardinal grifted off from Secret McSquirrel and Captain Corey. Yep. And I mean, I got a lot of flack from people who were like, why aren't you covering Rekida's stuff? And I'm like, well, I'm not covering Rekida's stuff because Rekida's stuff was legally boring. Like, it was very much an ordinary case, other than the fact that we know Nick Rekieta. And I mean, a lot of people were like cheering for his downfall. And I'm like, I'm not cheering for his downfall. I'm cheering for him to get back up again, right? I'm hoping that's what happens. And so there was a ton of people out there who just wanted me to go and like dunk on Nick. And it's like, well, life was doing that already. He doesn't need me to go and start kicking sand in his face. And the case itself was boring. Like, it just wasn't interesting. The only reason I would have covered it would have been for the Nick angle. And it's like, well, that doesn't interest me. Like the same way I wasn't interested in covering Johnny Depp until I watched some of the trial. And I was like, okay, this trial got interesting somehow. And I was waiting. I was keeping tabs on Rekieta's stuff, going like, if this ever turns interesting, I'll start covering it. But until it does, I'm not going to. So, yeah, just, I kind of was like, people were like, yeah, we're, watching things burn down and isn't this, great? And I'm like, I want to see him build back up again. I want to see, I want to see his kids have a good life. I want to see good things, right? And I mean, all of that is in Nick's power. I can't fix anything. So, yeah, that's it. That's all of it, right? So, yeah. Yeah, you were against Sarah Boone, but we appreciate you covering it. I kind of felt like Sarah Boone initially was just kind of kicking a sad puppy. And then Sarah Boone was like, you've lost my sympathy. And this trial actually is turning interesting. So we'll cover that. So, yeah, I mean, sometimes I'm wrong about what'll be interesting. Sometimes I watch, like, I see a trial and I'm like, this is going to be boring. And then it suddenly turns interesting. And then I'll start covering it. And people are like, oh, you came to this late. And I'm like, you bet I did. I thought it was going to be super boring. And I only started covering it when it got interesting. Because I cover the stuff that interests me. Right? I don't cover the stuff that I think is going to make, that's going to make money. Because I don't know. I cover the stuff that I think is going to be neat. So, yeah. All right. So, statutory right to obtain evidence. Cool. So this is all just, we have a right to evidence. Great. We know that. We know she's got a right to it. Moving on a little bit there. Defense request number 1. Request for all chain of custody logs, reports, evidence logs, and other documentation regarding how the district attorney's office and /or state police came into the possession of each distinct production of video surveillance footage from CPD that has been provided to the defense. This is a case that so much hinges on the police investigation, right? And so the police investigation requires them to, this more than any other case, they have to go through each element of the police investigation. And the thing is that most of the cases I have dealt with in my life, and most of the cases that most lawyers deal with in their life, the police investigation is fairly unremarkable. It's fairly uninteresting, right? It's fairly like, it'll be something like, here's an example of a police investigation. Liquor store reports a robbery. The person who committed the robbery is gone by the time the police get there. The police look around, but they don't find the guy. What they do is they pull the video of the robbery. They share it around with the police. One police officer recognizes the robber. They track that person down. They bring the robber in. They, sit him down in a room, and the robber initially says, I didn't do it. And then eventually says, well, I kind of did it a little bit. And, and then you go to trial. And so the actual investigation is pretty bog standard boring, right? Because it's just, okay. And so like for something like that, I don't typically need to know the exact details of when this video was downloaded, right? And who downloaded this, right? Those things are typically not needed or necessary or anything like that. But in this case, that becomes very relevant because there's allegations that all of these officers are engaged in some shenanigans. And so for their argument of shenanigans, they may need to know like which officer did this, because if it was Officer, Higgins, that becomes a big question, right? So that is why they need all of this. It's not, they're not asking for it for like no particular reason, right? So per defense counsel's November 8th email, Ms. Reid seeks discovery of all chain of custody logs, reports, evidence logs, and /or other documentation regarding how the Norfolk County District Attorney's Office and /or Massachusetts State Police came into the possession of each distinct production of the video surveillance footage from the Canton Police Department, which has been turned over to the defense in discovery, because they keep getting these dribs and drabs and weird little bits, right? The thing is that nobody, like, it's very weird that you get all of these bits and pieces of discovery. Most files I've dealt with, you know how the disclosure goes? The disclosure goes, I get one big package of everything all at once. Sometimes I'll get like, here's some more stuff as we process it, but it's very unusual to get different pieces of the same video released over time. So this has all been very strange. This information will provide defense counsel with relevant details about when, how, and from whom the Commonwealth obtained all of the CPD surveillance video footage, how it was logged into evidence, and what footage exactly the Commonwealth has in its possession and how that came to be. These details are relevant and necessary to contextualize the raw CPD surveillance footage and to assess whether that video footage was subject to tampering, i.e., who could have fudged this evidence? Who could have fiddled with it? Attorney Brennan indicated via email on November 25th, 2024, that he would request these records, but no records responsive to this request have been produced to date. So we want them, compel them. And they note, according to the Massachusetts rules, a statement includes writings or recordings made by a person having pertinent and percipient knowledge of relevant facts, and which contains such facts signed or otherwise adopted or approved of by such a person, or a stenographic, mechanical, electrical, or other recording or transcription thereof, which is a substantially verbatim recital of an oral declaration, and which is recorded contemporaneously with the making of the oral declaration. Statements may be formal or informal. Informal statements, not intended for court, are not only often admissible at trial, but often more probative than formal signed statements in anticipation of litigation, and should be disclosed. And evidence is considered exculpatory and thus subject to mandatory disclosure if it merely tends to diminish a defendant's culpability. It doesn't need to be an absolute acquittal, right? It doesn't need to be something that absolutely clears you. If it says that you might be a little less responsible, right? Yeah. Defense request number 2, an unredacted copy of MSP report number 26. So defense counsel also requested via November 8th, 2024 email to Brennan, an unredacted copy of MSP report number 26. And you might be saying, what is MSP report number 26? Why do I care about number 26? What's number 26? Well, they're about to tell us, and this is where things get fascinating. And you might be saying, Runkle, it's the middle of the night. It is way late. Why didn't you talk about the fascinating stuff first? Well, because I felt that this was the right order for things to get covered, and because I'm bad at grifting. But this is where things get fascinating, because it's associated with the investigation into the death of Sandra Birchmore. MSP report number 26 is relevant and must be provided in accordance with Ms. Reed's constitutional and statutory rights. The investigation into the death of Sandra Birchmore has involved many of the material witnesses in Ms. Reed's case, including but not limited to Sergeant Michael Lank, Daniel Whitley, Trooper Mike Dunn, Trooper Zach Clark, Colleen Crawford, Detective Kevin Albert, Lieutenant John Fanning, Trooper Gorino, Lieutenant Brian Tully, Deputy District Attorney Lynn Belland, and Belland, and District Attorney Michael Morrissey. Given the similar allegations of misconduct by state actors in the Birchmore and Reed cases, the statements that material witnesses in Ms. Reed's case made in relation to the Birchmore investigation are relevant for impeachment and bear on the credibility of those witnesses in the instant matter. So basically it's saying you guys did all sorts of misconduct on the Sandra Birchmore file, and that's relevant because it shows that you guys are a bunch of people what do misconducts, and so we get to dig into this. Now, here's the thing. In a very roundabout way, this may end up helping to bring justice for Sandra Birchmore. And what I mean by that is that right now, Sandra Birchmore, who's standing in Sandra Birchmore's corner? Nobody, right? Nobody is really in her corner other than like people online who've been following the case. They finally decided that they were going to lay some charges, but it seems, I'm not super satisfied by this. But now, and the thing is that ultimately, none of this team represents Sandra Birchmore or her family. They just don't, right? That's not what they're here for. But there is a really, really big element there about there's a really big aspect as to sort of a shared interest, because if the Karen Reed's team manages to dunk on and to uncover things with Sandra Birchmore, then Karen Reed's team ends up helping Sandra Birchmore in the process of helping Karen Reed, right? So Karen Reed's team, and people are saying we need a recap of Sandra Birchmore. So Sandra Birchmore is an absolutely tragic and messed up case. So what happened is that this woman, this underage woman, was involved with a police program, and she ends up meeting this police officer, Matthew Farwell. And he is alleged to basically have started grooming her and eventually beginning a sexual relationship, which was alleged to be fairly abusive. And later, eventually, she becomes pregnant. And in the course of this pregnancy, it becomes clear she intends to keep the pregnancy. Farwell is like, you cannot keep this pregnancy. You have to end this pregnancy. And yeah, so she later dies, and her death is initially ruled to be a suicide. It is initially ruled that she killed herself out of sadness and grief that her relationship wasn't going the way she wanted it to. And anyway, Sandra Birchmore's family has long said that this was not a suicide, that this was a homicide, and that this was that he killed her to cover up his involvement in grooming her, in sexually assaulting her, because none of that sexual contact was consensual because she's a child. and to basically keep his wife from finding out about this, keep all of this, right? And so ultimately, they say it's a suicide, and she is, it's very sad, but she just ended her own life. And everybody online was like, this is super suspicious. Anyway, he has now been charged with murder. So it turns out that this whole thing of like, this was just a suicide was not actually the case, because it turns out that this was a murder. And it was a murder where the police got it wrong about another police officer. And yeah, I mean, so the thing is defense here definitely wants to investigate this. And they're going to have suggestions, because the suggestions included that Farwell wasn't the only person doing this, and so forth. There were thousands of texts that apparently went missing in this case. And that, the people who got her texts and missed all of the texts also did analysis on Karen Reed's phone. So there's going to be questions about that. So yeah, basically defense is going to be like, listen, this shows how bad the police investigations are in Canton, how corrupt the police investigations are in Canton. And if they can introduce details about the Sandra Birchmore case in this, in Karen Reed's case, oh man, if they can open that door, if they can puncture that barrier and start bringing in the Sandra Birchmore stuff, it's going to, you saw the flamethrowering robot dog, right? That'll basically be what'll happen, is the flamethrowering robot dog will walk into the police station and set fire to things. That's essentially the metaphorical equivalent of if Alessi, Yannetti, Jackson, Little, and Betterow get to play around with the Sandra Birchmore stuff, then it's basically going to be they bring in the flamethrowing dog, and they just and everything goes to town. What I suspect is that Judge Cannone is probably going to say, I don't think it's relevant, but I don't know. I don't know for certain. And if she says, I don't think it's relevant, I think that defense is going to be trying to bait the prosecution into opening the door. They're going to be trying to bait these witnesses into opening the door as much as they can. So we'll see. I mean, it'll be an interesting matter there. But the Birchmore case is one of the most tragic, disgusting, horrible cases ever. And I did some coverage of it. You can find that in the sort of back catalog. And I will say, I don't recommend everybody watch it. I think my Birchmore thing basically started with, hey, here's a whole bunch of people, like a whole lot of you who are here should probably just go away and not watch this, because it is so horrific. It's just one of those things that makes you so mad. And I can tell you, like, I had people, I was raging during that stream, and I had people say that they appreciated that I was covering, like, that I was sort of willing to show some anger. And the thing is I didn't have any other choice. I was watching that and I was like, I'm going to try to not get angry in this. And then I failed. And it was basically just that if my options were either not covering it or covering it mad. So I covered it mad, because that's all there is. But it is like, after that case, I just went and, like, I had to hug the dogs. I had to just, like, sit there and be like, unclench all of your muscles, because it's just such an infuriating case. So I really hope that Yannetti Jackson, the dream team, gets to play in this particular playground, because I want to see them burning these police officers down. I want to see them just going nuclear. This is so that's what I want to see. That's where I want to be on this one. And quite frankly, they may have the opportunities to go through and just start asking these witnesses. So isn't it the case that with the Sandra Birchmore thing, you didn't get all of the text messages? Why didn't you get all the text messages? Does it have anything to do with the fact that Farwell is a cop? Is that why you didn't get the text messages? John O'Keefe is a cop. Okay. The Higginses, we got cops. We got cops in the Alberts. We got cops, we got cops all over the place, right? So, isn't it the case that you lose texts in order to protect police officers, or is that just convenient, right? I'm going to suggest to you that you lost these texts because Farwell was a cop. And the thing is you might have a jury who's sitting there going, holy shit, police officers in this town are the most corrupt pieces of garbage that has ever been. And the thing is you don't have to conclude that, but the jury, the Birchmore case is so infuriating, right? So infuriating. So, yeah. It is such a big thing. Despite defense counsel's request, the Commonwealth has not yet provided the defense with the report. In fact, Attorney Brennan replied on November 25th that because the Sandra Birchmore case now involves a federal investigation, defense counsel should seek redacted information from the United States Attorney's Office. Except the United States Attorney's Office aren't the people with the discovery obligation. That's the Commonwealth. The Commonwealth has possession, custody, or control of relevant reports from the Birchmore investigation that include statements by material witnesses in the Karen Read matter. Many of those statements have since been undermined and discredited, and consequently, they bear on the credibility of those material witnesses and are directly relevant to Ms. Read's case. I think they make a compelling argument here because of missing texts, because of the complete failure to properly investigate that case, which was an absolute horrifying and disgusting abandonment of the responsibility that they had towards Ms. Birchmore, a vulnerable child who was abused by one of their own. The fact that the U.S. Attorney's Office may have redacted information does not absolve the Commonwealth of their obligation to provide mandatory discovery under Rule 14. So, and they note, additionally, as explained infra in Section D, redacted reports omit information that is relevant to Ms. Read's case and critical to her defense, and thus are insufficient to satisfy the Commonwealth's discovery obligations. So accordingly, this request remains outstanding. This may be highly relevant to the Birchmore case, because this may be a time when a bunch of very skilled lawyers get to take apart some of the stuff on Birchmore and rip into these cops. And I just got to say, I am here for it, right? I am so down with watching some of these police officers get nuked over their behavior on the Birchmore case, and whether or not that means that they are corrupt, right? So, yeah. Defense request number 3, an unredacted copy of the public record response relating to all email correspondence and communications associated with the Sandra Birchmore investigation. In that same November 8th email, defense counsel requested an unredacted copy of the public record response relating to all email correspondence and communications associated with the investigation into Sandra Birchmore, produced in NOD 47. The Commonwealth has provided defense counsel with a copy of the response to a Public Records Act request concerning all email communication or correspondence and communications associated with the investigation into Sandra Birchmore. However, the copy that the Commonwealth produced is the same redacted version made available to members of the public. They're like, we want the unredacted. Critically, the interest of the public in obtaining and reviewing these communications is less substantial than those of the defense. The redacted version of the report omits information that is relevant to Ms. Reed's case and critical to her defense, and thus is insufficient to satisfy the Commonwealth's obligation under Massachusetts liberal discovery rules. And this is a point I just want to flag here. I have no idea how the cops could still want to protect him. If I had found out my brother did a fraction of what Farwell did, I immediately tell the police. And that also goes to police officers. I just want to note I was speaking at one point to a retired police officer, and he had a bunch, like I was at his house. He was showing me around. He was showing me all sorts of memorabilia and so forth from his career. And one of the things that he had in like this display case was a badge. And I was like, "Oh, was that your badge when you were on the force?" He's like, "Nope, that is my greatest trophy." And I was like, "Oh," and he's like, "Yeah, that's actually another cop's badge." And what it was is that other cop was sexually abusing women who were in his custody. That other police officer was a serial rapist for women he arrested. And this cop that I was talking to busted him. Like, he gathered the information. He brought the prosecution. He got that guy, arrested and charged and jailed and all of that. And when the guy lost his police badge because he got convicted of the sexual attacks on women, the police chief, who, when they took the badge back, they gave the badge to this cop and said basically, here you go. And so that was his greatest trophy, was the corrupt cop that he busted. And I was like, okay, that is a fantastic, trophy. And that's what I want to see on police forces, right? Cops who not only police the public, but hold themselves to not just the same standard as the public, but to a higher standard. Police officers who believe that the honor of the badge is worth protecting, that the honor of the badge is sacrosanct, that they have tremendous responsibility that goes with the power and regard that the public affords them. And that's who I want to see as police officers. Those are my favorite police officers, and I have nothing but undying respect for police officers who uphold those morals and those standards. And there are many of them out there. Unfortunately, if there's a bad police force, they tend to push those people out. Okay. So as described above, Attorney Brennan indicated to the defense on November 25th that if it wants these records, it should contact the U.S. Attorney's Office seeking redacted records. For the above-mentioned reasons, including the inadequacy of redacted records for defense purposes, the aforementioned relevance of these Birchmore records to Ms. Reed's case, and the legal obligation of the Commonwealth to provide such information when it is within its possession, custody, or control, that response is insufficient to satisfy the Commonwealth's discovery obligations. No records responsive to this request have been produced to date. So number 4, an unredacted copy of all reports, communications, handwritten law enforcement notes, and or other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in this case. So also on November 8th, Attorney Little requested an unredacted copy of all reports, communications, handwritten law enforcement notes, and / other documents from the investigation into the death of Sandra Birchmore, which relate to and / or reference material law enforcement witnesses in this case, which includes that entire list we went over before. As with the defense request, given the similar allegations of misconduct, the statements that material witnesses in Ms. Reed's case made in relation to the Birchmore investigation are relevant for impeachment and bear on credibility of those witnesses in the instant matter, i.e., If they lied in a previous investigation, then they're liars, and we get to cross-examine them on them being liars, right? In his November email, Attorney Brennan diverged from his previous response that defense counsel should seek materials on the Birchmore case from the U.S. attorney, stating instead that he was not in possession of these materials and referencing an ongoing defense Rule 17 motion. That reply is not responsive to the defense's request. There is no ongoing defense Rule 17 motion regarding unredacted reports, communication, handwritten law enforcement notes, and / other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in this case. Moreover, despite Attorney Brennan's assertion of the contrary, the Commonwealth is in constructive possession, care, and custody of these reports. The reports, communications, handwritten law enforcement notes, and other documents sought concern material law enforcement witnesses in the Reed case. Those witnesses are members of the prosecution team under Massachusetts law by virtue of their participation in investigating and evaluating the Reed case. Thus, their reports, communications, notes, and other documents are in the constructive possession of the Commonwealth. You say you don't have them, but the cops have them, and the cops are you, right? You are the cops. So turn them over. Request number 5. Request for all communications, documents, reports, memoranda, etc., relating to the internal affairs investigation into Trooper Michael Proctor, including transcripts of the administrative proceedings. You guys are punishing Trooper Proctor for being crappy. So we want that because Michael Proctor is super relevant to our case. Yeah. If anyone is looking for it, Ian's Birchmore stream was August 23rd, 2024. Cool. Excellent. So they requested the production of all the things related to that investigation. Attorney Brennan has provided defense counsel with a small number of generic letters about the internal affairs investigation, as well as an internal affairs report, which states simply that Trooper Proctor has been suspended. However, the Commonwealth has yet to provide any underlying documents or reports or documents detailing or relating to the substance of the investigation. So they're like, we don't just need to know that he was suspended. We also need to know like why he was suspended and how that investigation went down and what all was in there, right? We need all this information, not just some of this information. So, you gotta do better is basically what they're saying here. All right. So, however, the Commonwealth has yet to provide any underlying reports detailing or relating to the substance of the investigation. How'd the investigation go? New goal. Okay. Start another goal. Runkle life advice. We'll do another Runkle life advice. There we go. And I'll have to think about what the advice will be. On November 25th, 2024, Attorney Brennan replied to Attorney Little's request by asserting that he is not in possession of these materials other than documents he's already shared, and that he doesn't believe the Massachusetts State Police shares internal affairs information because, as he understands it, it is protected under Martin. Contrary to Attorney Brennan's suggestion, Martin does not hold directly that internal affairs information is protected and is not an absolute bar on the discovery of such materials, even under Rule 14. It is true that, although police officers generally fall within the definition of persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in the case, Massachusetts courts have recognized that internal affairs files in particular are not always in the possession, custody, or control of the Commonwealth. But the Supreme Judicial Court has held that if a prosecutor has possession or control of the records of an investigation by an internal affairs division of a police department with respect to a particular matter, the prosecutor must review that material in response to a Rule 14 motion for the production of exculpatory facts. And accordingly, the Commonwealth has a discovery obligation to provide any communications and documents that relate to the internal affairs investigation of Trooper Proctor and that are in its possession, custody, or control. We want this. We want it. So, yeah. The Commonwealth has not met this obligation to produce this evidence, and thus the defense seeks to compel its production. Cool. What is it? Possible Runkle advice: bury your Ethernet cables. My Ethernet cable is now buried, and it is good because Zora has no ability to destroy it anymore. All right. Request number 6. Request for all material and relevant communications. My shoulder is really killing me. Jeez. Ow. Made between members of law enforcement and witnesses in this case, including but not limited to Yuri Buchanek, the man with the interesting nickname, and Chris Albert, by email address and / or cell phone from the inception of this case to the present. The defense is requesting all written communications between and among the Norfolk County District Attorney's Office and its law enforcement agents and all witnesses in this case. The Stoughton District Court received a police report made by Yuri Buchanek regarding an instance of alleged witness intimidation. In his report, which appended a screenshot of a text message between Sergeant Buchanek and Chris Albert, Buchanek describes an incident that took place on July 10th, 2024, outside Chris Albert's business, the D&E Pizza Shop in Canton. Come for the pizza, stay for the corruption. I'm kidding. Sergeant Buchanek states that he was notified by Chris Albert. You shouldn't go to that pizza place. About an incident that Chris Albert considered to be threatening in nature. Sergeant Buchanek noted that in the text message communications between himself and Chris Albert wrote, "Hey, so I just had 2 women outside my shop taking pictures, which is fine. Then one woman lifted her hand and made a gun motion to her head. I watched it and have it on video." Or Sergeant Buchanek responded, "Please email it to me," and wrote, "Do you know who these women are?" Chris Albert replied, "No clue, I'll email it to you." In his report, Sergeant Buchanek also acknowledged that Chris Albert is one of the Commonwealth's witnesses in a murder case, directly referencing Commonwealth versus Karen Reed, i.e. she's got to turn it over. She's got to, The appended text message screenshot between Buchanek and Chris Albert, which constitutes material and relevant evidence and is a statement from a witness in this matter, is in the possession, custody, or control of the Commonwealth vis-a-vis Sergeant Buchanek, and was improperly withheld from the defense. Why didn't you give it to us? Sergeant Buchanek is an investigating officer who authored the police report detailing communications with Chris Albert, has been identified as a witness in the matter at hand, and is directly involved in the prosecution's preparation of this case. Accordingly, Sergeant Buchanek is an active member of the prosecution team under Massachusetts law, and his conduct, communications, and possession of evidence are imputed to the Commonwealth for purposes of Rule 14 discovery. i.e. Buchanek is you. And the thing is if they're taking pictures, and you've got them on like a surveillance camera video, and one of them does this, how do you infer that's a threat? Okay. The text messages from witness Chris Albert to Sergeant Buchanek constitute statements that must be disclosed. So, the relevant text messages were iMessages, text messages sent between Apple devices. So the Alberts use iPhones. I feel like that is a good advertisement for Android. Yeah. The text messages may also contain material exculpatory evidence that warrants production, i.e. there might be other stuff in here. The nature of the July 10th, 2024 exchange implies an ongoing line of communication that necessitates the need for all relevant communication via phone and email between Buchanek and Chris Albert since the inception of this case. The informal tone and casual language of the text messages between Buchanek and Chris Albert strongly suggest a pre-existing relationship and coordination. i.e. they're saying that one of the relevant things here is you guys are super friendly, right? You guys are super friendly with each other, aren't you? You guys are buddies. You know each other. This is part of their theory of corruption. So this inference is supported by Sergeant Buchanan's police report, in which he refers to being notified by Albert about the July 10th, 2024 incident and requests video evidence. The willingness of Chris Albert and Sergeant Buchanan to discuss material information pertaining to, they missed a word, pertaining Ms. Reed's case versus via text, as evidenced by the July 10th, 2024 exchange, suggests that other text messages between the two from the inception of this trial until the present may also contain relevant material and potentially exculpatory evidence that must be produced, i.e., these two might be talking about other things. They might be chatting about the case. And if they're chatting about the case, then that's a problem. The prosecution cannot avoid its discovery obligations by claiming these communications are covered by the work product doctrine or were conducted on personal devices or outside of formal channels. So, a prosecutor is expected to actively seek out any exculpatory evidence held by the Commonwealth or another member of the prosecution's team. This obligation to disclose exculpatory matter is just that, an obligation, not a decision. And they also note the work product doctrine exempts from discovery only those materials reflecting the legal research, opinions, theories, or conclusions of the adverse party or his attorney and legal staff. The doctrine exists to protect the mental processes and strategies of the prosecutor, not factual communications between law enforcement and witnesses. The doctrine encompasses prosecutors' notes made in preparation for trial, including notes from interviews with witnesses. The text messages between Buchanan and Chris Albert are factual in nature and do not contain any protected legal theories, strategies, or opinions. The communications appended to Sergeant Buchanan's police report consist of Chris Albert notifying Sergeant Buchanan of an incident, describing the actions of two women, and sharing video evidence. These exchanges are plainly factual and do not fall within the scope of the work product exception. So they're anticipating an objection from the other side, and they're saying that objection that they are planning to make, we think, has no value, has no merit, is just pure trash. It should be thrown out. And yeah, so that is that's where they're going with that. They see that there's a potential issue coming up, and they're like, "Yep, we see this coming. We are not going to. We're not gonna. We think that is a bad argument, and we're going to reject it ahead of schedule." Sort of. That's where they're going. All right. These communications were so whether Sergeant Buchanan used his personal or work cell phone emails to communicate with Chris Albert does not exempt the communication from disclosure. So even anything related to official business, even if conducted on personal devices or accounts, remains subject to public records laws and discovery. And you got to think, it's actually more harmful if the police are like, isn't it more concerning if Chris Albert is messaging key police officers on their personal phones than if he's messaging them on on phones that are like work phones, right? Doesn't that suggest more of a personal relationship? I kind of feel it does, right? Yeah. So I don't get it. What is it? These communications were included in Buchanan's police report, further confirming their relevance to the investigation and their status as official records. The inclusion of such material in a police report underscores its evidentiary value and negates any claim that it falls outside the Commonwealth's discovery obligations due to the work product exception. All right. So regardless of whether these communications are subject to mandatory discovery as statements, prosecutors are obligated under the rules to disclose any material and relevant evidence within their possession, custody, or control upon request. Here, Ms. Reed expressly requests that all material and relevant communications between law enforcement and civilian witnesses, including Yuri Bukaki and Chris Albert, made by email address and/or cell phone from the inception of this case to the present be disclosed in full compliance with Rule 14 and constitutional obligations under Brady. So, yeah. Number 7, provide copies of all notes, etc., relied upon by the Commonwealth's experts in completing their analysis, regardless of whether the witness will be testifying to the information at trial. You guys had a bunch of experts who you aren't going to bring to testify. We still want their notes, right? Any experts that you got, you need to use them. Let's see. I'm just checking on my goals here. The goal is sitting at 0 out of 10. I will grift the goal a bit and then we'll move back on. Okay. Defense request number 8. Provide all communications between members of the Norfolk County District Attorney's Office and / its law enforcement agents and all experts retained by the Commonwealth in connection with this case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and list of materials received. So they want all communications between the DA's office and its law enforcement agents and all experts. So they want all of those things. They want to know sort of what's going on there. So that's required. Lindsay, thank you so much. Defense request number 9, all written communications between them and any expert witness the Commonwealth intends to call. So it's, what is it? So it's everybody you don't intend to call, everybody you do intend to call. So they want all written communications. This information is necessary in order for counsel to be able to properly prepare for the cross-examination of these expert witnesses. And so they have to turn them over. Defense request number 10, a legible copy of this particular item. They produced a series of text messages which are completely illegible. Please provide us with the legible versions. You thought it was relevant enough to send us these text messages. So you got to send us these text messages in a form that we can read. And Lindsay, I see that the super sticker didn't count. It's okay. I appreciated it all the same. So yeah. Conclusion. The requested discovery is relevant within the custody or control of the government or its agents and essential for preparation of an effective defense. Massachusetts has adopted a liberal standard for what is considered relevant evidence. Most places have. Relevant usually means something that is vaguely connected. You know, something that might be helpful, not something that is like a smoking gun that clears your client, but something that might reduce your client's degree of fault. So even if evidence is remotely probative of a fact in controversy, it is relevant. As the Supreme Judicial Court advised in St. Germain, the Commonwealth should liberally disclose all material which is even possibly exculpatory as a prophylactic against reversible error and in order to save court time. If you think it might be relevant, then you got to turn it over. Production of the requested evidence will not produce unfair or substantial inconvenience to the Commonwealth, as these materials are within its actual and constructive custody or control. You have them. Turn them over, right? Denial of such discovery would violate Ms. Reed's constitutional rights to effective assistance of counsel and to due process under the law as guaranteed by Article 12 of the Massachusetts, all the Constitution, right? For the above reasons, Ms. Reed respectfully requests that this honorable court grant her motion to compel discovery. Respectfully signed, everybody. So, yeah. All right. So, let's cover super chats here. We'll just sort of discuss a little bit more after that. AKA the Cat Lady, you and Mike were a joy to watch together. I've never seen him laugh so hard. I really enjoyed that stream. I'm looking forward to hopefully going on another time. So, yeah. AKA the Cat Lady. Also, will we watch the Morrissey hostage video? Ooh, maybe we'll add that to the goal. Chat, we are at 3 out of 10. If we can hit 10 out of 10, I will throw up the Morrissey hostage video and we'll watch that. Annabelle Feinstein, Runkle, thanks for the rewind recap. I haven't followed Birchmore at all. It is a crazy case. Gray Space, if I die in Massachusetts, someone better call the FBI. I feel like, yeah, Lindsay, thank you for the super sticker. Much appreciated. AKA the Cat Lady says 0 out of 10 is sad, which took us to 1 out of 10. Fiona W says, I'm up for some life advice, which took us to 2 out of 10. Nice, baby. That is a quality rock pun for Runkle life advice. That takes us to 3 out of 10. How are we gonna manage on this one? Are we gonna get up to are we going to get up to all of that? I see take me to the hostage video. Turn up the volume on Runkle. I think I've got the volume up so that it's peaking a bit. So I don't think I can turn it up any higher than that. So bookmarks. Let me just see here. I gotta pull up the hostage video in case we get there. The hostage video is 5 minutes and 45 seconds, although I suspect it'll take longer for us to play it because we're going to have some comments as we go. Mispronounced name says, take me to the hostage video. I'm actually holding you guys hostage for the hostage video. Jaded Juror says, for the hostage vid, and thanks again for the Sandra update. Thank you. AKA the Cat Lady says, hostage video. Amesters00 says, thank you for keeping me company tonight. Also, let us watch Old Meatball. And Cat's Pajamas says, would like to see the hostage video. And that has us at 9 out of 10. Do we have one more person? Do we have one more person while I adjust my audio here? Greg says, prepare to be enraged. All right. Hopefully we've got this. There we go. Scott Rauch says, shut up and take my money. Laura Annie says, it is fun watching Runkle learn to grift. Thanks for the bonus stream. I'm trying. So guys, I have not watched this yet. I have not watched the, wait, is the super chat goal hostage video related? Count me in. You guys are past 10 out of 10. I see Vices would be proud of you. Thank you. Reese's mom, Vicky, video. We're over the goal, but I appreciate all of the things. So we are going to watch this. Hopefully the audio, hopefully I got it back piping through. Let us see here. Okay. Let me know if you guys can't hear this because I have not watched this yet.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses.
Can you guys hear it? John Smith says, I do not like the trend towards these goals. I'm bad at grifting, and I have done like 4-hour streams where I got like one super chat of $5. So I need to get better at the grifting so that I can hopefully reach the pro bono goals. And the goals help with the grifting. So yeah, I'm trying to do free work. Okay. So people are saying, yes, they can hear it. Okay. So he says this is the first statement of its kind. Let's keep watching.
In the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person.
Okay.
The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop.
Sir, you do not understand the internet because when you tell the internet you guys need to stop doing this, it is making me upset. It is making me sad. It's like, oh, sir, you have just poked the internet and they're gonna do it more. Like, and the thing is like, okay. I don't actually know that anybody, like, I haven't seen. Yeah, okay. Like, don't tell the internet what pisses you off.
Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died.
Dude, why are you making statements about the case where the jury might hear them? Also, somebody in the chat pointed out, and now I can't stop seeing it, that all of his volumes are not organized. So you see the Federal Reporter over here on the back. It goes 427, 430, 431, 418, 419, 434, 435, and then down at the bottom, 425, 423, 412, 44. Like, dude, organize your shit. And the thing is there is no way he's actually using these for anything other than a prop. Yeah. Why are you telling the potential jurors this?
Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home.
And
11
also shows that he went up and down the stairs in the yard. And shows that he could have been within the home within the margin of error.
people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night.
Yeah, here's the thing. It's up to the jury to decide the credibility of those.
0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home.
Why are you spreading this? It's like coming up and being like, I just want to say that Drake is not a pedophile. And it's like, and then everyone's like, wait a minute, why was he saying that? Does that mean that Drake, like, yeah, by the way, you might be wondering about all of these federal reporter things and what these are about. So let's talk about why you used to have these journals. It used to be that you needed to have these journals if you wanted to do legal research, because these journals would be all the publication of all of the cases. And the thing is that nobody uses these journals anymore, because instead you just get a subscription to Westlaw and you just use that. So this was in the days before like Westlaw, where you couldn't actually just go online and search the cases. So what role do these books have now? Well, now people have them so that it can be impressive when people come to your office. When you go to a, when you go to a law firm and you see all these journals on the wall, know that the only purpose of those journals in the modern era is to look impressive to you. And so my office has never had these because I don't believe in like showing off with stupid props. They just, yeah. Yeah, the other thing is that these things used to be insanely expensive. And so, yeah, they show off that you had the money to buy them back in the day. The same with the dictionaries. Those sets used to be thousands of dollars. Like, the Federal Reporter, thousands of dollars, right? And what is it? So the lawyers who didn't have huge amounts of money and huge space to have all of them went over to the courthouse law library and just worked off of those books. The lawyers who did have huge amounts of money would buy the journals. So yeah. All right. Here we go.
But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence.
Why is he running defense for people who aren't? Yeah. Kaylee says, didn't you say you didn't even have your law degree on the wall once upon a time? I think my law degree is over there. So let me just show you something about my law degree. It's on my shelf. It's buried under stuff, but let me just show you something about my law degree. And I got some stuff piled here because my room is full of stuff that needs to get shipped. Let me just show you about my law degree. You see that level of dust? Yeah, I haven't moved my law degree in some time. It has just been yeah. I don't even know where my YouTube plaque is. I'm not like a person for showing off, right? Because yeah.
There was no fight inside that home. John O'Keefe did not enter the home. Colin Elbert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative.
Then like he's like, this is a false narrative, and he's like, let me explain exactly what did not happen in this case. You know, it's like, wait a minute, there's a lot of details in this thing that didn't happen.
Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night.
I can really see why people are calling this the hostage video, because it really does feel like there's two guys in the back here with shotguns that are making him read this, because he's like, you know, like, yeah, why is he doing this? Like, there's no reason to do this. This is crazy.
They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case.
Also, I just want to say somebody needs to come out there and like fix his tie in the worst way. Like, this is like a pre-recorded video and like something that he's got staged and all of this. And it's like, and nobody told you that your tie was, you know, that like that. Like, come on.
To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted.
Blink twice if you're in danger. Guys, this is a situation where you might need like a duress word, you know, for like if you're in trouble, you know.
Conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision.
And they indicted, you know, Karen Reed and also a ham sandwich, because we all know about grand juries. So, yeah, I'm not super impressed with that.
The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong.
Oh, we heard the evidence at trial, and the evidence at trial was real bad. Like, you know, if you're like, hey, you're going to hear the evidence at trial and you're going to be super, you know, super on their side, I'm like, no. I was just like, how many people butt dial in this town? How many phones got destroyed? How many? Yeah. Yeah.
And certainly, before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police...
Yeah, but the evidence is real awkward in this case. Like, oh, come on. Why is he doing this? This video is so sketchy. Like, you shouldn't be doing a video like this where you're like announcing all of this stuff to taint the jury.
Department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no...
I mean, man, his delivery does not does not fill me with confidence. I get why people call this the hostage video.
Close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now.
Or what? Like, people are allowed to have opinions and like, or what? Are you gonna like hide under their bed and slash their ankles? Like, what is it you are? It needs to stop now. You know, like, come on. I'm
releasing this recorded statement rather than holding a news conference because my remarks need to be so...
Because if this was a live conference, you'd see the guy with the shotgun.
narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
Or what? Or what? Also, it's kind of funny the YouTube suggestions that came up. Because I've got a little bit of politics, CBC News. I've got a lot of Karen Reed. There's three Karen Reed things, one Sandra Birchmore, but I've also got Hades 2, the song I Am Gonna Claw Out Your Eyes and Drown You to Death is there. Bard Michael Kelly's song of Jolene, the H.P. Lovecraft version, is up. Electric Callboy is up. Man, that is such a dumb video. How did he think that was going to help? Like, I don't think So yeah, Greg says, prepare to be enraged, Ian. Scott Roach says, shut up and take my money. Technogeneric says, wait, is the super chat goal hostage video related? Count me in. There you go. Reese's mom says video. Amber C says, you're the best, Ian. Keep up the grift. I proudly support grifters. I'm bad at it. Elise says, is it legal for him to publicly say this? I think there's ethical problems with this, but that'll be a matter for him and the ethical board. 2WNE, he check out his eyebrows. His eyebrows are all over the place in that. And you could probably you could probably find a bear hiding in his eyebrows. What the actual F? Yep, you're not wrong. Laura Liani says, grift for the pro bono goal. Thank you so much. Just because, do you think they'll find Brian Albert's fingerprints on Morrissey's lenses? They look like they haven't been cleaned since 2021. Lenses or like belt? And yes, this was before the first trial. So like he's talking to the potential jury pool here. Yeah. So that is, and I see an ethics violation was filed with the state board over that video. Yep, I can see it. So, yeah. What is that? Sarah in shock and horror. Thank you for the 10 gifted memberships. Bulldog Mom, late but glad I'm catching a live. Thank you, Ian. Gundy, yes. I haven't got the Gundy trophy. That'll come in like 2 years. Gray Space, the witnesses in this trial are presumed innocent. They absolutely are. But that's a legal presumption. That isn't, we're not required to have that opinion ourselves. That is a legal presumption. Sarah in shock and horror, thank you for the YouTube membership. Zed says, please check Turtle Boy's article on Karen Reed grand jury. I'll have to try to find that. Against the Tide, please like and check out Rule of Law, Unusual Rescue. I did a stream. If I get to doing like the pro bono stuff, I will try to do like a every 2 weeks role-playing stream. That's what I would love to do. Honk Banana, no. What they don't tell you is this video is flipped. Solid. Just because we don't try people on the internet because the internet isn't a legal jurisdiction. Same reason you can't form a company on the internet. Yeah. Louisiana Girl or what? Look what happened to Turtle Boy. Fair. Debbie W. This is going to sound weird, but take a look at the books behind Morrissey. Trust me, they're in a weird order for sure. I feel like if you go into that office and you adjust the books so that the numbers are in order, then a secret passage opens and it's got like a weird little shrine to like Colin Alberts. It's got like, bits of Colin Alberts hair in there. Did he just say a role-playing stream? Yes, like tabletop role-playing games. So yeah. B. Gene, thank you for the 5 gifted memberships. And Gwynny Bly says, host vid should have been shorter. Do not harass witnesses. Believe in the jury system. There are heightened emotions. Please have compassion for each other. Absolutely. There's a way he could have done that would not have been super crazy. He could have just gone and said, hey, there have been a lot of tensions are running high on this case. I am asking the public to wait for the trial, wait for the verdict, and that harassment of witnesses is unacceptable. Regardless of how you feel, nobody should be harassing witnesses. This is an ongoing case. Do not do it. Cool, done. You've got a statement out there condemning that. You don't need to anything else. And I got to roll this. And then I got to actually find it. Zero Your Heroes is to help you go free of charge. I just got to find it in the back scroll here. Where'd it go? There we go. Help you to go free of charge. Thank you so much. I really appreciate it. And Bulldog Mom, thank you for the 5 gifted memberships. Yeah, that was something else. I do not know how they did it. And yeah, I see somebody saying if my books were like that, I'd have to get up in the middle of the night to go fix them. Yeah, it's crazy. What is with this town? It is such a weird little town. I don't get it. I do not get it at all. So, all right. It is now 11 o'clock. What is it? Aren't the jurors required to presume innocence? Yes, the jurors are. The public isn't. Like, I can believe personally, if I want, I can believe that that Morrissey killed them. I don't, but if I believe that, it's not a violation of the presumption of innocence. It's just my beliefs, right? You know, and I see Edward Scott with a very good point. I'm sure they're framing Karen Reed, but harassing the witnesses is literally counterproductive to the case. The very first time these people should have been answering difficult questions is on stand. I agree. Nobody should be harassing witnesses. People should be leaving the witnesses alone. But this video was weird. So I feel like there's a better way to do this video, and I feel like there's not many worse ways to do this video. I mean, there are worse ways to do this video. He could have done this video naked. That would be worse. I'm out of ideas. So Jade says, what is your best guess as to who killed John? The thing is, I don't know. I've got multiple theories on that one. I'm just like, yeah, I mean, it seems most likely that a fight happened in that house, but I don't know who got in the fight. I don't know where they got in the fight. Oh my God, did you just watch the hostage video? We just watched the hostage video. Naked, but with the crooked tie. Oh my God, that would be terrible. Yeah, it's such a... I'm going to have to watch that one again sometime just to think about it, like, in the meantime. Because, yeah, I don't get it. I personally think that, like, Canton could be vastly improved if they fired every police officer there, like every single police officer, like, you know, down to the guy who, like, has just been hired, every single police officer, and hired all new cops, none of whom had any connection to any of this. So, yeah, I don't see it. So, anyway, it is now close to 11 at night. I see Greg saying, can't wait to see Mark Betterow in action. Me as well. It is also 4:15. So we are, yes, I guess I can do that. Can we get one more view of the dog paintings, please? I think I can do that. I got to be careful with them because I don't want to handle them too much. I want to get them framed rather than handled too much. Yeah, I see somebody saying drain the pond. They need to not just drain the pond, but they need to, like, pour gasoline in it and set it on fire just to purge it. So the paintings. Painting 1 of Potter. Potter's so cute. I love my pups so much. I really do. They are such sweethearts, and these capture them so well. Painting number 2, Zora. It shows her mischief. I see the Zora painting, and I'm like, what are you up to? What are you doing? And painting 3, Potter. Whoop. I hope I didn't show anything that I shouldn't have. Painting 3, Potter with a pineapple. Somebody sent him this stuffed pineapple. Potter does this thing. So we get him, like, chew toys, but Potter refuses to chew his chew toys. Because what'll happen is he'll find a chew toy that he likes, and once he decides he likes that chew toy, he doesn't want to chew it. He doesn't want to destroy it. And they're paint. Somebody was asking, are they chalk, oil, pencil, paint, or a photo? They're paint. So what he does is he picks them up and he just, like, carries them, and he'll sit there and he'll snuggle his little chew toy. So, like, somebody sent in, like, an elf chew toy, and so he won't chew that. He will play with the, like, he'll sit there and hug the elf. Celestial Heather says they're acrylic. Okay. So not oil, they're acrylic paint. So yeah, he just he's got a chicken that he likes, and he will not chew them. He doesn't want to destroy them. He doesn't want to damage them. He's just like, I love my toy. And it is the cutest thing. He's just like, yeah, he's just like, I just want to snuggle this. So what if I gave him two of the same toy? He will just same thing. So he's such a sweetheart. He just every dog we had before this will destroy them. And the thing is that Zora learned this habit from Potter, because Zora used to chew toys. And it used to be a thing that would actually, we'd have to keep Potter's toys away from Zora because she would destroy them. And like Zora would chew the out of the toys, and then Potter would be sad because he'd have a toy he liked, and Zora would chew the crap out of it, and then he'd be like, "Oh, I lost my cute toy." And anyway, he's taught Zora not to chew toys. He taught her to respect the chew toys, and so now she will pick them up and she'll take them places, but she doesn't chew them anymore. And it's like, ah. The other thing that is super, super cute. So Potter loves the cold. Potter loves the cold. He is like, in the summer, he is lazy because he doesn't want to run around in the heat because he overheats. But in the winter, he's like, I get to run, I get to play. This is my best time. So in the morning, the dogs go out and they run. Zora does not have the same cold tolerance that Potter has. So Zora is like, she comes and she's like, I need to come back in. Meanwhile, Potter is like, I'm not ready to come in. I'm not coming in. I'm going to run in the snow. And then Zora will warm up in the house for a bit. And then she'll be like, I miss Potter. I am lonely. I miss Potter. And then she wants to go out to be with Potter. So then they'll run around in the snow some more. And about the second round of running in the snow, Potter will be like, I want to come in. And then Zora's ready to come in. So they're both coming in at the same time now. And then they'll hang out inside for a little bit. And then they will be like, there is no snow in the house for us to frolic in. So it's time to go back out. And then they're like, we're going back out. So that is what they do. That is, they just do their thing. Somebody says, does Potter have toys he likes that he does chew? He doesn't chew any of the toys. So yeah. They're sweethearts. I love them to bits. And all right. I am going to wrap things up here. There's two more super chats that I'll cover before we go. Michael J. Money says, Morrissey is just like Lally. They're only attempting to fight the defense and not focused on proving their case. This case shouldn't have been brought. This case has so many problems with it. Louisiana Girl, thank you for the new membership. Honestly, the biggest favor that they really could have done the police on this case, like the biggest favor that they could have done for like Trooper Michael Proctor and so forth, is they really could have said, you know what? We're just going to say that the evidence, like we're just going to make a public statement saying the evidence in this case is, unfortunately, we cannot conclude beyond a reasonable doubt that, that a jury, or we don't think that a jury is going to find guilt beyond a reasonable doubt. So we've decided that because of problems with the evidence in this case, we're not going to proceed. And then Trooper Michael Proctor's, like, his shit would not have been in the public. All of them wouldn't have had to get up and say butt dial a million times. Like all of this, it would have been such a huge favor to all of these people. I don't know why they're doing this. It's crazy. So anyway, thank you guys all for joining me. I'm going to go. My voice is starting to give out, and tomorrow I have to go and be in trial or in court. Not trial. It's just a boring appearance, but I got to go be in court early in the morning. So I'm going to do that. So I will catch you guys later. I might be able to do a stream tomorrow. I don't know if I can. It'll probably be late because I'm hoping to take Mrs. Runkle out for a dinner. I don't know if it'll be possible. We don't actually have a reservation, but we're going to see. So I will have to play it by ear. Anyway, good night all, and see you next time.